learning platform, and I'm here to share whatever I have understood regarding related party transactions under IBC. And please feel free to interrupt me and ask any queries as and when you have doubts. And I'm also open to any suggestions or any other further inputs from the members. Just a moment. Yes. So today we will start the presentation with the basic understanding of who is a related party, post which we will discuss the provisions under the code also. So who is related party is covered under the Companies Act, the rules thereunder, the secretarial standards also have some stipulations. Apart from that, we have the LODR regulations which talk about related party transactions. We have the accounting standards, both PAS 18 and Ind AS 24. The Income Tax Act also is concerned with the related party transactions. More in income tax is more concerned with the evasion of tax and whether there is any transaction to circumvent the tax provisions. So there, we will not be focusing on income tax provisions for this session. And then our core area of insolvency and bankruptcy code and the regulations thereunder. Why Companies Act is very important is because the, as we know, the definitions, some of the definitions are not covered under the IBC, for which we will be drawing reference to the Companies Act, and we will be reading both together to understand the related party transactions. So now the first question is to why at all we should regulate the related party transactions. So the reason why we've noted down some as there is diversion of funds and of assets from the company to other companies, persons, may not directly be promoters, to maybe to other persons also. And it benefits the promoters and directors, which it's okay if it benefits them, but what the problem arises when it is detrimental to the others. So there are other stakeholders in the company who should also get a fair share in the benefit derived from the company, to which the promoters exclude them. So this becomes a prejudice to the non-related stakeholders who are directly not monitoring the day-to-day activity of the company, but have invested under the belief that the promoters and directors will safeguard their interest. And then there are transactions which we call the PUFE transactions, which is the preferential transactions which are covered under the section 43 of the code. And then we have, and then we have undervalued transactions covered under section 45 of the code, and transactions defrauding creditors under section 49, extortionate credit transactions under 50, and we have fraudulent trading and wrongful trading, with a very fine distinction under section 66 covered under subsection 1 and 2. And above all this, we also have to take into account the principles of natural justice, which have to be upheld so that there is fair treatment to all the stakeholders under a IBC process or any other process for that matter. So today, what we will be covering. So we will look at all the regulatory bodies. So related party transactions are regulated by MCA as far as the Companies Act provisions are concerned, SEBI in the case of listed companies, CIBIL to the extent of the credit ratings that they do, the tracking that they do to ensure that the NPAs are properly tagged and the information is made available. And not only CIBIL, maybe other credit rating agencies also can be included. And then the NCLT and NCLAT for both the Companies Act and IBC provisions which they oversee. And the Income Tax Appellate Tribunal, which makes sure that the orders passed under the Income Tax Act are fair and accordingly addressed. Today, we will be covering in related party under the Insolvency and the Bankruptcy Code, and to what are the provisions covered under the CIRP regulations. Then we will move on to the liquidation regulations, and we will end with the pre-pack regulations. Wherever the concept of related party and wherever is covered, we will cover all that in today's presentation. So I will first start with the definition of a related party. So we go to section 524 of the code, where it says that the related party in relation to a corporate debtor means. So we are first seeing the first part of the related party definition, which is in relation to a corporate debtor. There was a separate insertion to the code 24 capital A, which spoke about related party in relation to an individual. So we will first cover the corporate debtor part. So it says means a director or partner of the corporate debtor or a relative of a director or a partner of the corporate debtor. So initially, we will have to understand who are all the relatives under the IBC, for which also there is a separate definition, which we will see later. And the second part is the key managerial personnel of a corporate debtor or a relative of the key managerial personnel. Now, as far as point A is concerned, the director or partner of a corporate debtor, we would be able to pull out to some extent from the MCA records. A relative of a director or partner, we may be able to take from MBP 1, provided those details are available with the corporate debtor, or the promoter declares. But B, when we look at key managerial personnel is not defined under IBC. So we will have to take the definition under Companies Act. And the relative of key managerial personnel, I feel, would be a challenge, because getting that information for an insolvency professional might be a little difficult. I would like to hear from the members how they kind of trace this out in the absence of information from the corporate data. And C is on the limited liability partnership or partnership firm in which the director, partner, or manager of the corporate debtor is a relative, or his relative is a partner. Again, the challenge of tracing all these companies to make sure that the disclosures are there, and maybe to some extent we can take information from the related party disclosure under the financial statements. The auditors may have, as they would be certifying accounting standards in their audit report and financial statements. To some extent, we may be able to pull out this information, but most of the companies we take up, we know that the financials for the last 1 or 2 years would not be available and would not have been audited. So this is another challenge as to how to determine who are all the related parties and which will fall under this clause. So then we move on to clause D. So clause D says a private company in which the director, partner, or manager of the corporate debtor is a director and holds along with his relatives more than 2% of its capital. This may be easier to trace. We will have the data on the MCA website. E, a public company in which the director or partner or manager of the corporate debtor is a director and holds along with his relatives more than 2% of the paid up capital. So here again, there is a twin condition in both D and E, which says you have to be a director, partner, or manager and also hold 2%. If both these conditions are not satisfied, only one condition is satisfied, you will not be treated as a related party. Then we move on to clause F. Any body corporate whose board of directors, managing director, or manager in the ordinary course of business acts on the advice, directions, or instructions of a director, partner, or manager of the corporate debtor. So here we have one more challenge. How do we determine whether he is acting on the advice, directions, or instructions of the director? If there is an agreement to this effect, and we have access to that agreement, if it is a shareholders agreement or an investor agreement, we may be able to determine this. But in the absence of that, it is an oral arrangement or an internal arrangement, or you don't have access to that documentation. It would be very difficult to prove that he is acting on the advice, direction, and instructions of the partner. The same words, advice, directions, or instructions, are also appearing in the Companies Act. If we look at the definition of promoter in the Companies Act under section 2, subsection 69, I will just read it out for all of you. So section 2, subsection 69 of the Companies Act says promoter means a person, A, who has been named as such in the prospectus or is identified by the company in the annual return referred to in section 92, or B, who has control over the affairs of the company directly or indirectly, whether as a shareholder, director, or otherwise, or C, in accordance with whose advice, directions, or instructions the board of directors of the company is accustomed to act. So if we see, it is the same wordings which has been taken from this. And there is one provision also to this, which says, provided that nothing in subclause C shall apply to a person who is acting merely in a professional capacity. So drawing inference from this, so we will go by the same way we trace the promoters under Companies Act to the related party under the IBC. So I will move on to clause G, which says any limited liability partnership or partnership firm whose partners or employees in the ordinary course of business act on the advice, directions, or instructions of the director, partner, or manager. Here again, tracing the partners may be possible, but employees of the LLP or the partnership firm would be little tricky to trace. And until and unless we are able to prove they work out of the same office or their portfolio or their letters and their signatures, what they have signed, all prove to act in the capacity of employee of the corporate debtor and of the partnership firm or LLP. Then on clause H, any person on whose advice, directions, or instructions a director, partner, or manager of the corporate debtor is accustomed to act. So the same words accustomed to act we saw under section 269 of the Companies Act. And then I, a body corporate, which is a holding, subsidiary, or an associate company of the corporate debtor, or a subsidiary of the holding company to which the corporate debtor is a subsidiary. So we call it that where you have a common holding company or a co-subsidiary, different words used in common parlance. Now I will just go back to clause H, which talks about accustomed to act. So when you say accustomed to act, there are two kinds of control. There is a positive control and a negative control. So when we say there is a positive control, suppose there is an investor who says, I have some affirmative vote, or he wants certain issues to be brought to the board of directors and he wants a say in them, which we call an affirmative vote. Then in that case, can we say the person is accustomed to act as per the advice of the director or partner or manager? So we have nominee directors on the board by the investor. So will those people also fall under this category of H and become a related party? One more question I would like to throw up on is, if there is a son is there, is the son always deemed to be examined on a case-to-case basis and decide whether it will be falling under the related party in absence of any written agreement or any other documentation that we are able to get? We'll move on to J. Any person who controls on account of ownership or a voting agreement. So we have the concept of differential voting rights also. So in case they are controlling the voting also, it will come under related party. Okay. Any person in whom the corporate debtor controls more than 20% of the voting right. So the first J talks about also talks about control, and K also talks about control on account of ownership or voting agreement. So there is a very fine distinction between J and K that we see here. So J says any person who controls more than 20%, and K, any person in whom the corporate debtor controls more than 20%. And L, any person who can control the composition of board of directors or corresponding governing body of the corporate debtor. So we are all these J, K, and L talk about control. Move on to M.
Best example is Sahara with regard to this. The point number L. Best example. Best example is that.
Correct. So when we say governing body under L, we may cover any kind of trust or any other kind of body which will come, which is not directly into the, that is why I think they are using the word governing body here.
Yes. The basic crux, if you take it in Sahara, it's a partnership firm which starts the whole process.
Yes. Then we will move on to M. Any person who is associated with the corporate debtor on account of. So it talks about any person here. So we'll have to look at the definition of person under the IBC. So I will just read out for clarity. Section 3, subsection 23 has the definition of person. It's an inclusive definition. So it says person includes an individual, a Hindu undivided family, a company, a trust, a partnership, a limited liability partnership, and any other entity established under a statute, and includes a person resident outside India. So the challenge is to how to include a person who is resident outside India and also bring him into the related party, restrictions under this code. So I'll read it again. Any person who is associated with the corporate debtor on account of one, participation in the policy making process of the corporate debtor, or having more than two directors in common between the corporate debtor and such person, or interchange of managerial personnel between the corporate debtor and such person, or provision of essential technical information to and from the corporate debtor. So here, instead of having only one director, they have said you should have minimum two directors common between the corporate debtor and such person. That is one we noted. And they also say interchange of managerial personnel between the corporate debtor. So maybe the intention is to say that if you are having a common company secretary or a common CFO who is taking care of both the persons, then it will become a related party. And also he is covering provision of essential technical information to or from the corporate debtor, which means if there is a group of companies where which one company is providing the technical information, maybe another company is providing the financial support, or they are doing the manufacturing activity. So then if it is all related, then this will also become a related party. Now, with this, we complete the definition of related party in relation to the corporate debtor. We will move on to the related party in relation to an individual. So this definition was not there in the original code, was inserted only with effect from 6/6/2018. And that way IBC has been an evolving law, and every time there has been some circumvention of the provisions, the lawmaker has been quick to amend and add provisions and make it very dynamic, and it's adapting to the needs of the law, the insolvency scenario. So we will start with the related party in relation to an individual. A person who is a relative of the individual or relative of the spouse of the individual. So we are left with a very wide web of relatives here, where you have to, the individual itself is very complex. Now you have to get information about the spouse, and the relative definition we will see going forward how wide it is. Be a partner of a limited liability partnership or a limited liability partnership or a partnership firm in which the individual is a partner. C, person who is a trustee of the trust in which the beneficiary of the trust includes the individual, or the terms of the trust confer a power on the trustee which may be exercised for the benefit of the individual. So this is typically happens in the case of family trusts, where the trust is formed and all the estate properties are put into the trust. And in case this particular person is named as the beneficiary of the trust, which means he will get a property, share of the property, then he is deemed to be a related party. D, a private company in which the individual is a director and holds along with his relatives more than 2% of its share capital. So here again, it's a twin condition. E, public company in which the individual is a director and holds along with his relatives more than 2%. here the distinction, earlier definition also had this distinction where when they talk about more than 2% in D, they say of its share capital, whereas when it comes to E, they say of its paid up share capital. I'm unable to understand the reason for this distinction, but it is there. And F, a body corporate whose board of directors, managing director or manager in the ordinary course of business acts on the advice, directions or instructions of the individual, similar to what we discussed in the earlier definition. So what is ordinary course of business? We will be discussing in the forthcoming slides. On G, a limited liability partnership or a partnership firm whose partners or employees in the ordinary course of business act on the advice, directions or instructions of the individual. Again, the similar definition we saw earlier. H, a person on whose advice, directions or instructions the individual is accustomed to act. I, a company where the individual or individual along with its related party own more than 50% of the share capital of the company or controls the appointment of the board of directors. So here they have brought in a higher threshold of 50%. Now we will move on to the explanation of what is relative. So relative with reference to any person, anyone who is related to another in the following manner. So we know the definition under Companies Act, and now we have the definition under IBC also. One, it says members of the Hindu undivided family, husband, wife, father, mother, son, daughter. Till this it is easy. Now we move on, sons, daughter and son, daughters, daughter and son, grandsons, daughter and son. So they are moving on to something like the fourth generation here, and granddaughters, daughter and son. I don't know how many people will live to see four generations below. And brother and sister, then brother, son and daughter, sister, son and daughter. After this, they move up. The father's father and mother, mother's father and mother. Then you have the father's brother and sister and the mother's brother and sister. So essentially, we come 3 generations down and 2 generations up and 1 generation, maybe 2 generations sideways also. It doesn't stop here. So it says wherever the relationship is of a son, daughter, sister, or brother, their spouses also shall be included. So we go into the relationship of a son-in-law, daughter-in-law, sister-in-law, brother-in-law. Everybody is also covered under the relative definition. Maybe they found that people are circumventing the law by transferring it to relationships which are not covered as a relative under the Companies Act. And that is why the law foresaw that and added into this act. So now we'll cover under the code where or not there is a reference to relative or related party and what is the implication of all these references. So first is the appointment of an insolvency professional or an authorized representative. So the resolution professional is one of the backbones of the resolution process, apart from the pillars, which are the adjudicating authority, the insolvency and bankruptcy board. And then we have the institutes which govern the insolvency professional. And of course, the COC, which performs a major role in the taking forward the IBC process. So in all these cases, the law wants to ensure that it is governed by only unrelated parties and there is no related parties sitting in any of these positions. So being regulators, obviously, IBBI and ICS, I mean, the IIPs don't require this provision. But the insolvency professionals, the authorized representatives and the committee of creditors, these are the pillars where we have to ensure that related parties do not enter. So the resolution professional has to be independent to provide the adequate support to the committee of creditors and to make sure that the process is carried out in an independent and fair and transparent manner. Then we have authorized representatives who represent the class of creditors. So under the code, they also have to maintain their independence and they should not be anyway related to the corporate debtor or to the financial creditor. Then there are professionals which are appointed by the insolvency professional during the course of the process, either as an IRP or as an RP or as a liquidator. So the professionals may be registered valuers, legal professionals, and these professionals are also governed by their individual code of conduct. So if we take registered valuers or if we take advocates, they will themselves not undertake if there is a conflict of interest. But the issue comes in the case of when you appoint accountants for the process to help the insolvency professional out, or when you appoint any kind of consultant, if the company is into any specialized business and you need a consultant who will take this process forward, then you will need to ensure that the person is completely independent of the corporate debtor and all the promoters, and it is not a related party. Regular declarations are required to be given by the insolvency professional to the ICSI IIP, giving the relationship disclosure on a periodical basis as soon as they are appointed. All this ensures that the process is, carried on in a manner that is above the bar, and it is always safe for both parties so that there are no allegations from the promoter or any person later. So it is better to do a proper due diligence of all this before we take up the assignment. And in case there is anything that comes to our notice in between, we should always excuse ourselves from the appointment. That is what is expected of every professional, and I'm sure everybody understands that. Now we'll move on to the section 21, which talks about the representation of the financial creditors on the committee of creditors. So a financial creditor or an authorized representative of the financial creditor, if he is a related party to the corporate debtor, will not have any right of representation, participation, or voting of the committee in the meeting of the committee of creditors. So when we see the claim form that is filed by the financial creditor in Form C in the case was the ARP process, there is a declaration saying that he is not related to the corporate debtor and is not a related party. So that is inbuilt in the form of the Form C. But still, it is a duty cast upon the insolvency professional to check whether he is a related party before it is included on the committee of creditors. There are some cases which have happened where the IRP has included them in the committee of creditors, and later there has been other financial creditors have pointed out that it is a related party and requested them to be removed. So we will see those instances going forward. There is one exception to this, which talks about a financial creditor regulated by a financial sector regulator. If it is a related party of the corporate debtor solely on account of conversion or substitution of debt into equity shares, or instruments convertible into equity shares, or completion of such transactions as may be prescribed prior to the insolvency commencement date, then he will not be treated as the related party. So here what is important is that this action should have been taken prior to the insolvency commencement date. Now we will see who is a financial sector regulator. So section 3 subsection 18 defines who is a financial sector regulator. Means an authority or body constituted under any law for the time being in force to regulate the services or transactions of financial sector, and includes the Reserve Bank of India, SEBI, IRDA, the Pension Funds Regulator Authority, and such other regulatory authorities as may be notified by the central government. So only if it is regulated through any of these, it's an inclusive definition, so we can the central government can notify and add more. But currently it is only these 4 institutions, which if you're regulated by either of these 4 institutions, then you can call yourself as a person regulated by a financial sector regulator. There is one dichotomy in this which says that you will have to give notice to the suspended directors or to the related party, but they will not have right to representation or participation or voting. So then the question arises that when you are giving notice to the suspended director, which is mandatory under the provisions of the code, after having given notice, whether you should forward the entire agenda and all the related documents to them, or it only the bare notice which will be an information for them, and because they will not have any right to participate or represent in the meeting. So this is something which has been going to court back and forth, and there are some cases on this also, which we will also look into. So now the first, one of the first duties of the insolvency professionals is to validate the claims, and once they are done, form the list of stakeholders and post that form the committee of creditors. So the law also addresses that where the corporate debtor has no financial creditors or all the financial creditors are related parties, then the COC shall comprise of 18 largest OCs by value, one workman representative, and one employee representative, which is provided under Regulation 16 of the CIRP regulations. So in the absence of any of the financial creditors, the OCs will take the process forward. Now we will look at reasons as to why we should exclude the related party financial creditors from the IBC process. So the very purpose of IBC is that the financial creditors should take control of the committee of creditors and also steer the process forward, which is also as per what we our code envisages, which has been taken from the ancestral legislative suggestions. So first, there should be no conflict of interest, and they should not have any negative influence on the process. Related parties, including them in the process, could lead to differential treatment and affect the interest of the valid stakeholders. And the rights of legitimate creditors have to be protected, which is one of the duties of the insolvency court. And the COC has to exercise its commercial wisdom to make the insolvency process successful, which would be derailed if there are related parties on the COC. And the democratic pattern of the majority view should not be made a mockery by allowing the related parties to have a say in the process, because there is a deemed presumption that the related parties would have some information about the past process, how the funds have been siphoned off, or what they will have to hide from the process, or how they want to steer the process forward for their gain. So that is the reason why it is necessary to exclude the financial creditors from the process. Now we look at assignment of debt. What happens when a debt is assigned to a non-related party? So typically we see that promoters plan the system very well, where they make sure that when they foresee that the company is going into insolvency and they are not able to pay their debts, they slowly start, siphoning off funds. They start planning that when the company goes into IBC, how their voting power will be ensured. So one way what they do is they start assigning the debts to the related party debts to non-related parties. And then they try to get into the COC and thereby trying to influence the decisions. So there is one case where the Pankaj Yadav versus State Bank of India, which was before the NCLAT, where the NCLAT has noted that there is a meticulous planning by the director of the CD to bring down the voting power of SBI. So had the assignment not happened in this case, SBI would have had a good majority on the COC, which intentionally was brought down by the directors by assigning their debts to the non-related party. And it is the NCLAT has also observed that if a related party financial creditor ceases to be a related party with the sole intention of participating in the COC and sabotage the CIRP process by diluting the vote share of the other creditors or otherwise, the disqualification should apply to such party as well. So the conduct of the promoters and how they have planned has been shown very brought to the notice of the NCLAT, and this observation has been made. So there is one more similar case in the case of Radha Industries. In the case of Radha Industries in the Bradeshwar Vidyut matter, where the CD converted dues to the operational creditor amounting to 10.29 crores into a financial loan. So what was due to an operational creditor for supply was converted into a financial loan under the premise that he is not able to pay the operational dues. And subsequently, CD did not repay the loan. And what happened was it was assigned to another company by deed of assignment cum novation dated 2/4/2019 for a consideration of 13.61 crores. So the act of the initial due of 10.29 was increased to 13.61 and it was assigned in 2019. Subsequently, in the CARP commenced on 27/1/2020, and at the first COC, 10 creditors were shortlisted by the IRP based on her initial the audit that she had done and the background that she had checked. 10 creditors were called to the COC meeting. At the first COC meeting, the 6 financial creditors objected to the adding of these 4 creditors onto the COC, saying that they are related parties. So they had done their due diligence and found out that these parties were only through an assignment of debt and were the underlying transaction is still a related party transaction, and more so because it was an operational debt which was converted into a financial debt just a little prior to the commencement of CIRP. So obviously they were in privy of the matter before the NCLT and accordingly acted to backdate this. And NCLAT also noted here that the reason for the applicant taking over the bad loan of the CD is not clear and it's rather surprising. Because why would the CD take over the operational debt, convert it into a financial debt? And the adjudicating authority also observed that whatever the rights of the original assigner got from the original lender will automatically accrue to the subsequent assignees based on the executing appropriate legal documents in accordance with law. So the adjudicating authority here was a considered view that the applicant being an assignee of the loan from the assigner is also a related party of the CD. So basically, you cannot get a title better than what was there with the original owner. This was what was decided in the case. There is one more matter where it was held that before the NCLT Allahabad bench, which said that the CD's directors themselves or their relatives were also directors of the financial creditor, then they fell well within the definition of the related party. This, I think, was clear from the definition, but still it has been taken to NCLT. One more issue that we face is the nominee director on the board of the corporate data. So we are aware of lot of shareholders agreements which or joint venture agreements which provide sometimes for the financial assistance to the corporate data, and in return they would want a nominee director on the board of the company to oversee the business of the company, the operations of the company, and also to protect their financial interest in the company. So in this one case where the RP decided that the financial creditor was not eligible to be made a part of the COC, and it said 8% of the shareholding in the corporate debtor. And the adjudicating authority held that as the management of the company, an affirmative vote in the company many a times be used to protect their investment in the company and have their say in the proper usage of funds that may have nominee directors. These are all incidental rights to protect their interest in the debtor company, which said that merely having this affirmative vote right does not disqualify a nominee director of a financial creditor to be a related party. And the NCLT Chennai went on to say that if these financial service providers acting as trustees to some other funds are eliminated from participating in the COC, then the very objective of bringing the debtor companies under financial creditors will be put to nullification. That apart, it also said that the valuable right of a financial creditor who has come into the company solely for return on investment as per the agreement will be unreasonably curtailed. So this is the view of the Honorable NCLT Chennai. We move on to the same matter was taken up before NCLAT, and in NCLAT, the observations were slightly different from that of the NCLT. So what the NCLAT observed in the same matter was the affirmative vote items demonstrate substantial control over the technical matters, including the very choice of technical professionals such as architects, and was well within the investor's domain for whom the investor representative was acting. So the NCLAT went one step further in looking at the control that was exercised by the nominee director and said that it had a very direct say in all the operational matters of the corporate debtor, and having such direct control over the corporate debtor, it would also have to be taken in as a related party to the corporate debtor, which has failed and come under insolvency. So here the applicant held 8% of the shareholding of the corporate debtor and also had funded around 49.5 crores through debentures. Here the appellant, what he did was before the NCLAT, he annexed the debenture certificate, which said that the debenture is not convertible but redeemable on maturity, which he tried to prove that he is only a financial investor and had no direct rights or any say in the management of the company or the failure of the company. And he also pleaded that he is a financial service provider regulated by SEBI. So here the NCLAT had gone through all these issues and has held that this investor managers limited, Ask Investor Management Limited, is a related party to the corporate debtor, and therefore it cannot be made part of COC with voting rights. So the same conclusion the NCLAT has also arrived at after looking at all the facts and the control that has been exercised by the nominee director. So if the nominee director had been a simpliciter nominee director on the board, then it would have been acceptable. But since all these affirmative votes were there and also that they were actively participating in the operations of the company. So this is very important when we as other advisors, we advise the company on to have a nominee director on the board. So this is a flag as to how we should draft our shareholder agreements or look at how the representatives are nominated on the board of the investor companies. Now we will look at what is permitted RPT. So what is done in the ordinary course of business, that is a normal activity taken by the company. And maybe it is there in the main objects of the memorandum of association. The activity is frequent. So the frequency of activity is one of the conditions that we can check to see whether it is in the ordinary course of business. And the past record of these transactions and the percentage of contribution to the total revenue. So all these will determine whether it is in the ordinary course of business. But when we check ordinary course of business, we have to see whether both parties, it is ordinary course of business, not only for one party. So when there are two or more parties to the transaction, it should be an ordinary course of business for all these parties. And one very important underlying condition is that it should be for the benefit of the corporate debtor. So how do we determine? So for example, if the company is selling out this machinery, old machinery, and if it is sold to the related party, for this for corporate debtor, it might be in the ordinary course of business. But for the company which is buying, we have to see whether to that company also it is in the ordinary course of business. If it is not, then it will not be following the test of ordinary course of business. One more test that we do is arm's length transaction. So arm's length transaction has two aspects to it. One, whether the terms are the same and the price is the same that we give to the other non-related parties. So this also can be checked with the past track record, where we are having when the same transaction is done with non-related parties, similar to how we check under the Companies Act also. And transfer pricing can be kept as a guideline to check whether the arm's length pricing has been done. All these activities would require compliances under the Companies Act, so that can be cross-verified. And also the auditors, what they have commented upon in the auditor's report and how it has been declared in the financial statements would all determine whether this is a permitted related party transaction or a transaction which requires some kind of investigation. There's a request to distinguish between related party and a connected person. It is there in the subsequent slides. I will take it up. Okay. Next, we move on to some more details on what is ordinary course of business. So there have been a lot of cases under the Companies Act which speaks about ordinary course of business. There is one case of the BNB Paribas versus United Breweries, which was the Karnataka High Court case, which says that while dealing with Section 562 of the Companies Act 1956 on the issue of disposition of property during the pendency of winding up petition before the company judge, has defined the words in the ordinary course of business. So what has been observed is that honest dispositions made in ordinary course of business are usually allowed. So the court recognizes that at the time of distress, when the company is under financial distress, it will try to sell some of its assets and settle the liabilities. So honest dispositions made are allowed. But it is also saying that while passing orders, the court considers whether the transaction in question is in furtherance of the company's business or in the interest of the company in liquidation and or its creditors. So that is the test that has to be applied, which says that is it, so what you have done with the money, what has been disposed, is it a substantial asset which is generating revenue for the company that has been disposed? Or if it is some asset which is not generating revenue and that is why it is being disposed to settle off the creditors. And secondly, who are the creditors to whom it has been given, whether it is a related party or a financial creditor. In certain circumstances, the court has seen that it is only to those financial creditors where personal guarantees have been given, or it might be to some diversion of funds for some other purpose. So the purpose is also very important when we come to the ordinary course of business. So this matter, there is one more observation that says before the winding up petition is presented, it is in the ordinary course of business for a company to pay all its debts and incidentally to give security to its bankers for any overdraft or loan it may arrange. But after the petition is presented, the situation is different. Prima facie, all the debts will have to be paid pari passu. Therefore, it is no longer in the ordinary course of business to pay one creditor in full to the detriment of his fellow creditors. So it is the intent and the way it has been executed, which will determine whether it is in the ordinary course of business. In either which case, after the petition has been presented, if there is an activity that has taken place, then it will not be treated as normal ordinary course of business unless it is paid to all the creditors pari passu basis. So there is a look back period under IBC which says 2 years prior to the insolvency commencement date. I understand there is a proposal to amend this and make it 2 years prior to the date of submission of the application under section 7, 9 or 10 before the NCLT. This would be a welcome move because in this period, typically promoters do siphon off a lot of funds, sell off assets. Okay. Now we move on to the approval of the committee of creditors for certain actions. So section 28 of the code specifies what are all the actions to which the IRP or RP has to go before the committee of creditors. With respect to related party transactions, it is mentioned that the RP during CARP should not enter into any related party transaction without the prior approval of the committee of creditors. So here it is very clear. It is not a post approval. It is prior approval that has to be taken. There are some challenges in this. For example, what happens when the IRP takes over but the committee of creditors has not yet been formed? In the interim, that 1 month, there are some critical decisions which have to be taken. The company may be run with related parties who are the suspended directors, their relatives. So the question arises as to how we are able to manage those 30 days with so does it mean that you cannot employ the existing related parties who are already there in the company or undertake transactions with the related parties, provided the company is a going concern? And then how do you take prior approval? And even after forming of the committee of creditors, if the management is currently being run by relatives of the promoter and the directors, then how we will deal with this situation? Is it that we will have to remove them from the post immediately and replace, which may also be a challenge in the case of a company under insolvency? So all these aspects need to be considered and accordingly taken forward. Maybe it has to be presented well to the COC and make sure that the COC approval is obtained. Okay, so we will look at one more matter in the case of NCLT Ahmedabad, where what happened was that the IRP had some faced with the same situation, where the suspended board of directors were holding managerial positions in the company and they were withdrawing salary. So the salary was approximately 5 lakhs per person per month. And they were taking care of all the functions, operations of the company. And once the IRP took over, the IRP had the power to appoint professionals to take the resolution process forward. So what the IRP did was the IRP requested the existing suspended board of directors to continue to do their task in running the business and help the IRP in running the business of the company. Now, when the COC was formed and the resolution was placed before the COC that there is how the IRP had requested them to continue and they had to be paid for their services, the COC rejected the resolution for payment of salary. And so the aggrieved directors went before the NCLT, and the NCLT held that the commercial wisdom of COC is supreme and that it required prior approval. And if the COC is not willing to pay their salaries, then it cannot be paid. So they refused to interfere with the decision of the COC. Next, we move on to the information memorandum. So the information memorandum has to be prepared within the 54th day of the insolvency commencement date. So the challenge here is that a lot of information has to be available, compiled, and prepared in a logical manner and placed before the COC before the 54th day. So in that, there are two clauses which relate to related party. So one, it says that the particulars of debt due from or to the corporate debtor with respect to related parties. This has to be disclosed in the IM. And the second is details of guarantees that have been given in relation to the debts of the corporate debtor by persons, specifying which of the guarantors is a related party. So here two things IMB will have to disclose. One is on the debt that is due, and the second is on the guarantees which have been given. So both these details have to be combined and placed in the IM. Just give me a moment, please. So next we will move on to one of the very important parts of the code, which speaks about section 29 capital A, which was introduced with retrospective effect from 23/11/2017. We will see going forward how it was introduced. So section 29 capital A deals with persons not eligible to be a resolution applicant. This is very important for an RP to know who is not eligible, because whenever a resolution applicant applies, we will have to check whether they fall under any of these parameters and whether they are eligible to give the resolution plan. And if you are the professional who is drafting the resolution plan, then also it is very important for us to check whether the person is qualified to give a resolution plan. There are some agencies which undertake specialized services they provide to check whether the person is disqualified, because the ambit is very wide, especially we have seen how wide the related party and relative definitions are under the code. And to scout and search in public record where they have been declared insolvent or willful defaulter, or any of their companies in which have been declared in the past. So we will now see section 29 capital A. Thus, a person shall not be eligible to submit a resolution plan if such person or any other person acting jointly in concern with such person is an undischarged insolvent or a willful defaulter in accordance with the guidelines of Reserve Bank of India issued under the Banking Regulation Act. Who at the time of submission of the resolution plan has an account or an account of the corporate debtor under the same management or control of such person, of whom person is a promoter classified as an NPA in accordance with the guidelines of the Reserve Bank of India or the guidelines of a financial sector regulator issued under any law for the time being in force. And at least a period of 1 year has lapsed from the date of such classification till the date of commencement of the CARP process of the corporate debtor. So there is a time period given, interim time period of 1 year, within which you can apply, failing which you will fall into the disqualification under section 29 capital A. And they are saying if you make payment of the overdue amounts along with the interest thereon and all the charges that have been levied on you being an NPA before the submission of the resolution plan, then this disqualification will not apply. So the Supreme Court took a very lenient view in the case of the ArcelorMittal case, where it permitted the parties to set right their NPA accounts and then come back and submit the resolution plan, because the condition here is it was to be done before the submission of resolution plan. So the court has taken a lenient view in certain cases and allowed the resubmission after setting right the default. in the interest of the corporate debtor and in the interest of all the financial institutions which have lent to the corporate debtor. And it also says that there is one more provision which says that nothing in this clause will apply to a resolution applicant where such applicant is a financial entity and is not a related party to the corporate debtor. So financial entity merely holding shares on account of conversion or any other such rights that they are having on the board will not be treated as a disqualified person. Now there is one explanation to section 29 capital A, which says for the purpose of this provision, the expression related party shall not include a financial entity regulated by a financial sector regulator if it is a financial creditor of the corporate debtor and is a related party of the corporate debtor solely on account of conversion or substitution of the debt into equity shares or instruments convertible into equity shares or completion of such transactions as may be prescribed prior to the insolvency commencement date. So there are two important aspects to this explanation, which says it will not include a financial entity and it will also, it has to be done prior to the insolvency commencement date. Who are all the entities which are, who are all the financial sector regulators? We have already seen the definition. And we also know who are all the financial entities. We saw the case also. Moving on to explanation 2 to section 29 capital A, which says it is for the purpose of this clause alone where a resolution applicant has an account or an account of the corporate debtor under the same management or control of such person or of whom such person is a promoter classified as an NPA and such account was acquired pursuant to a prior resolution plan acquired under the court, then the provisions of this clause will not apply. There are multiple conditions here as well, which says that if the promoter was classified as an NPA and it was prior to the resolution plan being approved, then this provisions of clause will not apply to such resolution applicant for a period of 3 years from the date of approval of the resolution plan. It is assumed that within 3 years, the account will be no longer an NPA. One more subsection D of section 29 capital A, which says he has been convicted for any offense punishable with imprisonment for 2 years or more under any act specified under the 12th schedule or for 7 years or more under any law for timing in force. So the 12th schedule to IBC lists out more than 20 acts under which person should not be imprisoned or convicted for any offense with imprisonment. And another clause is that 7 years or more under any law for time being in force. So provided that this clause shall not apply to a person after the expiry of 2 years from the date of his release from imprisonment. So the clause is also very lenient, which says even if you have been there for 7 years in jail, after 2 years you are exempt from this. So this is one of the another leeways. Basically, the intention of law had it been to keep fraudulent promoters away from the management and taking over the management of other companies. This is a bit too lenient provision. And it also says that this clause shall not apply in relation to a connected person referred to in clause C of explanation 1. We will see who is a connected person. He is disqualified to act as a director on the Companies Act 2013. So here again, there is a exemption to a connected person referred to in clause 3 of explanation 1 alone, not 1 and 2, clauses 1 and 2. So disqualification to act as a director under the Companies Act. We are all aware of section 164, which provides for the disqualification of directors. In that, there are two parts to section 164. Please allow me to take that 1 minute. There is one recent judgment in the matter of Apu Hotels, which has also discussed the matter of section 164 disqualification. So under section 164, there is a subsection 1 which says who are all are not, who are all are disqualified. basically covering person of unsound mind, undischarged, insolvent, which are convicted of court of any offense. And then there is a subsection 2, which says that no person who is or has been a director of the company which A has not filed financial statements or annual returns for a continuous period of 3 financial years. This would be evident from the MCA records. Or B has failed to repay deposits accepted by it, or pay interest thereon, or redeem any debentures on the due date, or pay interest thereon, or pay dividend declared, and such failure to pay redeem continues for a period of 1 year or more, shall be eligible to be appointed as a director of a company. In the recent Supreme Court judgment, it has been upheld that for the purpose of Section 164(2)(b), there should be a specific order of the ROC or the adjudicating authority to say that the person is disqualified. The RP cannot unilaterally take it that he is disqualified based on the examining of the financial statements or other records of the companies in which he is a director. So now it is sufficient if what data is available on the MCA website in terms of annual return filings is examined by the RP. Till, of course, some other law, the law is amended in this matter. So we move on to F, which says is prohibited by the Securities Exchange Board of India from trading in securities or accessing the securities market. G has been a promoter in the management and control of the corporate debtor in which preferential transactions, undervalued, extortionate, or fraudulent transaction has taken place, and in respect of which an order has been made by the adjudicating authority under this court. So here again, the law is very clear. There should be an order. There is no presumption of transactions or no authority for the resolution professional to check until and unless there is an order passed by the NCF or any other authority under the code. So there is one more exception proviso given to this clause, even for the PUFE transactions. It says if it has taken place prior to the acquisition of the corporate debtor by the resolution applicant, pursuant to a resolution plan approved under this code, or a scheme or a plan approved by a financial sector regulator or any court, and such resolution applicant has not otherwise contributed to these PUFE transactions, then the resolution applicant will not be disqualified from the giving a resolution plan under the code. So section 29A would not apply to this case also. Then it says he has executed a guarantee in favor of the creditor in respect of a corporate debtor against which an application for insolvency resolution has been made by such creditor and has been admitted under this code, and such guarantee has been invoked by the creditor and remains unpaid. So here again, there are multiple conditions which are there. When PUFE transactions are pending, then this clause will not apply. Only when there is an order under the code, then this order will apply. Disqualification will apply. And then it's saying is subject to any disability corresponding to clauses A to H under any law in a jurisdiction outside India. I understand this is very, very difficult to verify as to how it would be if it is outside India. The next is so, and J, we have a connected person is not eligible under clauses A to I. So we will now move on to who is a connected person. So the explanation talks about who is a connected person. So connected person, it says one, any person who is a promoter or in the management or control of the resolution applicant, or any person who shall be the promoter in the management or control of the business of the corporate debtor during the implementation of the resolution plan, or the holding, subsidiary, associate, or related party of a person referred to in clauses 1 and 2. So earlier we had seen under section 29 capital A. Yeah, under 29 capital A, specific exemption had been given to those under the explanation 3. Which were the clauses was that one, it is to disqualify to act as a director under the Companies Act 2013. To them, there was exemption. So exemption is only with related to 3, which says holding subsidiary, associate, or related party of the persons referred to in 1 and 2. It is an exemption to those people for a disqualification under the Companies Act. And one more exemption which was given was for the purpose of conviction of any offense punishable with imprisonment. In both these cases, for subsection 3 alone, 29 capital A has given an exemption. Other than that, any other person would be deemed to be a connected person. Now, the challenge that we have in the connected person is that if he is a promoter in the control management, it is relatively easier for us to determine. Whereas to get the related party of these people, so getting the promoter, identifying the promoter is possible. But now we have to check whether the resolution applicant is anyway termed as a related party to the holding company, subsidiary company, associate company of this promoter company, or if the promoter is an individual, any of the relatives of the individual. Similarly, under clause 2, any person who shall be a promoter during the implementation of the resolution plan. So we'll have to see the resolution plan that has been submitted. And in case there is any person who is being shown as in the management or control of the business during the implementation of the resolution plan, such persons' antecedents, holding company, subsidiary company would also have to be verified to see whether there is any disqualification that is applicable. Now, the one very important issue on the connected person is it should be connected with business activity. So what a typical example that comes to mind is that of Anil Ambani and Mukesh Ambani, where we see that it is a well-publicized fact that there has been a partition in the family, and it was also well known for which are all the companies which are controlled by Anil Ambani, which are all the companies which are controlled by Mukesh Ambani. So since the entire matter has been publicized and the partition has happened, it paved way for Mukesh Ambani to take over some assets of Anil Ambani, which had gone into insolvency. And the court recognized that even though they were relatives under the IBC, but they were no longer having any common business activity, and the brothers did not have a say in each other's business. And that paved way for Mukesh Ambani to take over the control of some of the assets of Reliance Communication, which were required by Jio for its services, and which also helped in solving the insolvency and getting good value to the Anil Ambani group. So certain rare scenarios are available where the definition of relative has been given a go-by by the court, and the court has allowed in the interest of justice. Must appreciate the dynamic way in which the law has been amended, and also the court has also been taking a very lenient view in cases in the interest of justice. One more matter in the case of ArcelorMittal also, which I have noted down in the subsequent slides, which the court has taken an exception and allowed the resolution applicants to submit the plan. So what happened prior to section 29 capital A was that any individual or body corporate could participate in the resolution process. There was no differentiation between the promoter, director, related or unrelated persons. And it was a heaven for fraudulent promoters to get back their companies with haircut. So prior to introduction of 29 capital A, the promoters themselves brought in resolution plans, or through their associates, they brought in resolution plans got back control of the company, and the promoters had to take a huge haircut, sometimes 90%, over 90% haircut. And the promoters got their company back, control back, scot-free. And to prevent all this, the lawmakers woke up immediately and decided to introduce this 29 capital A to make sure that these fraudulent promoters do not get back their company, and all other stakeholders' interests are also protected. And instead of going for an OTS proposal or any kind of settlement with the bankers, the promoters found that this being a resolution applicant and taking through a resolution plan gave them, salvaged them from all the past sins that they had committed, and also got them the company back with a huge haircut. Bankers were also very hesitant to sign a OTS proposal or any kind of, when it comes to a huge haircut like this. But minute it goes under the court process and it comes under with the stamp of the honorable adjudicating authority, then the bankers were also comfortable in going through huge haircuts. So to prevent all this in the interest of the society at large, Section 29 Capital A was introduced. So it was inserted through the Insolvency and Bankruptcy Code Amendment Ordinance in 2017 with effect from 23rd November 2017. And after the court was back, the parliament was back in session, the Insolvency and Bankruptcy Code Second Amendment Act 2018 was passed. And so that is why we mentioned that it is retrospectively effective from 23rd of November 2017. That is the date when the ordinance was passed. So the lawmaker here again did not wait for the parliament to be in session, but they decided to go ahead with the ordinance route. The preamble to the ordinance gives us an idea as to why 29 Capital A was introduced. This is the lawmaker's perspective. So I'll just read out this relevant paragraph. It says, and whereas in order to strengthen further the insolvency resolution process, it has been considered necessary to provide for prohibition of certain persons from submitting a resolution plan, who on account of their antecedents may adversely impact the credibility of the process under the code. And whereas it is also considered necessary to make provisions to specify certain additional requirements for submission and consideration of the resolution plan before its approval by the Committee of Creditors. So by this ordinance, first Section 29 Capital A was introduced by way of the Amendment Act of 2018. It was brought into effect again, and also the definition of relative was introduced only through the Amendment Act. So I guess the preamble clearly entails what is the reason behind bringing this 29 Capital A to the code. So next we will see what is the need for Section 29 Capital A. So avoidance transactions typically erode the value of the corporate debtor. It is with an intent to defraud the creditors, and that had to be put into check. And those associated with these avoidance transactions should not be eligible to bid for other companies or their own corporate data. And there is something called a twilight period, not defined anywhere, but generally used parlance, which is the period prior to the commencement of the insolvency proceeding, the insolvency commencement date, but the period during which the promoters were aware the company is going to go into insolvency. So this period would be typically the period when the application has been filed before NCLT, but it is pending approval. Or it might be also the period where the promoter is aware that the company will go into insolvency and any of the creditors or the promoter himself plans to apply for insolvency. And in the interim period, they try to undertake some transactions to take away assets or funds away from the company. It is also that related parties have additional information regarding the company's affairs, which is not available to the other stakeholders. And they may use this additional information to divert the assets of the company. Promoters take advantage of the early signs of financial distress to their advantage, and they divert the funds or assets. Typically, it is seen that if the company is, say, for example, into a retail outlet, and employees are not being paid their salary, so they tend to take away items given to them. So if they are given a cycle or a bike, or if they are given some office convenience, mobile phones, they typically take it away in lieu of their salary if they estimate that the salary is not going to be given to them. So taking advantage of these situations, promoter themselves take some assets and blame it on the employees, or they may use some other form of, moving it away from the premises and keeping it in some other place and passing on the blame to the landlord or to the creditors or to the employees. What we typically see in a lot of cases. And one more reason why 29 capital A is necessary is to lift the corporate veil, where the fraudulent promoters hide behind a web of companies. And ultimately, the beneficial owner, as we see under Companies Act, the declaration of the SPO is also important. Will also help us in identifying who is the person who is having ultimate control over these companies and make sure that it doesn't go back to the same fraudulent practice. And another reason is the promoters of defaulting companies have to be kept away from resolution process. Not only this company, any company that they are having which have defaulted, then they should be kept away from the resolution process of other companies to make sure that the same thing is not repeated in this company also. Next is that Section 29A was also necessary to bring credibility to the resolution process, to give assurance to the industry and to the public at large that the process is intended for their benefit. And early resolution is important. At the same time, it should be a fair process. So same promoters who contributed to the downfall of the company should not get back the company, which is again against the basic principles of corporate governance. So we will stop here and maybe take a small break and resume after 15 minutes. Anjali, are you there? We'll just take a short break for 15 minutes and we'll resume. Thank you. is more for a related party than compared to a non-related party. The purpose and obvious reasons for that are now there is a presumption that interest was acquired or benefit was received otherwise than in good faith unless the contrary is shown. So the law is that presumption is always that it is otherwise than in good faith, and the promoter will have to prove that it was in good faith. There is a proviso to this. There are two things that the promoter had sufficient information of the initiation or commencement of insolvency process, and he is a related party. So these two conditions, if they are satisfied, there is a presumption that it is not done in good faith, and the promoter will have to prove that the avoidance transaction was done in good faith. The onus of proof is on the promoter. On to section 46, which talks about avoidable transactions. Avoidable transactions also the same stipulation, 1 year if it is any person, and if it is a related party, it goes to a period of 2 years, the look back period. So this is as per the ancestral legislative guide on insolvency law, which has suggested that the look back period should be longer in the case of a related party than in the case of an unrelated party. Now, how to determine the if there is a PUFE transaction? So the RP to form an opinion on or before the 75th day of the insolvency commencement date. And the transactions may be covered under 43, 45, 50, or 66. And he has to make a determination of such transactions on or before the 115th day. Apply to, I think there's a slight mistake in the number of count. Apply to A on or before the 113th day. I'll just check and correct it. And the creditors shall provide to the RP an extract of the audit report, such as the stock audit, transaction audit, forensic audit, which they have conducted. This will help in checking whether there are already existing any transactions which have been noted, which can be used by the RP. So typical transactions which fall under this PUFE transactions would be like repayment of the unsecured loans taken from relatives, payment to creditors to avoid section 138 cases. That is where post-dated checks have already been issued. You specifically make sure those creditors are paid in priority. Or sometimes without any antecedent debts, the payment is made. Then payment for old debts is made instead of payment to the current vendors. Salary is paid to directors and their relatives. Payment of loans guaranteed by directors and promoters is given priority. Contracts are awarded to relatives or group companies, by which ones are siphoned off. These are all the flag points that the RP can have. So the loans to directors and relatives, selling of investments at a value below the market price, especially in the case of unlisted securities, or ad hoc, giving off the securities to an ARC or any other related party, assignment of receivables at a lower value, payment in excess of market price, then sale of machinery or assets at a low value. Another very important thing is the transfer of IPRs or technology in the name of the promoter. So what the company has spent and acquired the IPR or technology is transferred in the name of a promoter for a very nominal value. Reclassification of operational debt into financial debt. We saw a case also relating to this, where the court had struck it down. Deployment of funds not involving the core business of the company. That is also a flag. So here the underlying intent is very important. Whether the promoters or the suspended directors have undertaken all these transactions with an intent to defraud the creditors. So how to check? We have all the three IPAs together have brought out a statement of best practices, role of IPs in avoidance proceedings. So if you look at that statement of best practices, they have listed out how an RP should check if there are any PUFE transactions in the corporate data. So this verify the end use of funds granted by the lenders, identification of cases involving siphoning off of funds, and misrepresentation of financial information, violation of RPT norms, verification and tracing movement of unsecured loans, intercorporate deposits, especially those raised in group concerns, concentrating transactions, verification of aging receivables, including advance given debit balances with vendors and large amounts of write-off, which is a flag. Then transactions with related parties. Large transactions with unrelated parties also would have to be checked because they may not strictly fall within the definition of a related party, but still indirectly when you check, they may be a related party. Salaries, benefits to KMPs, movement of cash, transactions with group companies to see whether there is diversion of funds, sale of assets, transfer of contracts, investments made by the company, inventory details. So under investments, typically what happens is they buy shares at a huge value so that funds are deployed into another company. So the valuation of the investments would have to be checked. Suspicious movements in the financials, that is in the previous year and current year. If you see the previous year balances would not be carried forward to the current year. Transactions routed through related parties and potentially linked parties, and whether these are at arm's length and for specific purpose. This also can be checked to determine whether it is a POF transaction. Some more check. So there is an indicative list of what all we have to check for in respect of these suspicious transactions. So purchases and sales made from or to relatively unknown parties at rates which are very much higher than the market value. And then the perusal of payments made which previously indicate that there is diversion of funds under different activities like selling, general expenses, repairs, legal expenses, high salaries, perks to directors and KMP, high raw material cost, all these are there. Then large amount of write-off on account of recoverable made without adequate justifications. And so here it is obvious that write-off has been made, but no effort has been taken to recover the dues. Misrepresentation in the statements or data provided to banks for acquiring higher limits and availing withdrawals from banks. Typically, the inventory is highly inflated, which is why the auditor's report now has been amended. The financial statements have been amended, disclosures under Schedule 3 to show what is the stock available. Other than that, there might be where we have seen the Satyam case or other cases where they're showing a huge inflated balance in the balance sheet, which is not supported by the actual assets. Non-existence of parties to whom money is to be recovered and outstanding. So when we have a receivable list and we go and check those people, it is found that those entities don't exist. So they're just fictitious entries in the books of account. Major change in accounting policies, including valuation of assets and in provisioning and depreciation, impact on these are the financials of the corporate debtor. The transaction involved in transfer of property or other asset and investment of the corporate debtor to third parties and the terms of such transactions. Major liabilities including contingent liabilities, disputes, legal cases, tax liabilities, penalties that has not been adequately reported in the financial statements and appropriate action has not been taken. Very difficult to trace the liabilities which have not been reported in the financial statements, but maybe part of it can be traced from the claims, and if there are any missing entries that were there in the previous year but missing in the current year, these are all flags that can be found out. Obviously, when the bank statements of the CD, the financials are not available, will indicate what are the transactions that have happened that the bankers will generally share. Search from publicly available information, details of charges, hypothecations. You can send letters to the debtors for accounts receivables, because there may be chances that the debtors are only shown in the books of accounts to manipulate the books. This is also a role of the RP that has been given. Verify orders passed by authorities against the corporate debtor, which may help in identifying the areas of concern. Physical verification of assets will show that whether the assets shown in the balance sheet are actually available in possession of the company. And fixed assets of substantial value, if they are sold or disposed of before the insolvency commencement date, that's a cause of concern. Then tracking of inventory towards invoicing or stock in a particular write-off of inventory, cash transactions, purchases from unregistered dealers, service providers, which may be fixed parties. So if you can check if they have a GST registration or if they have any legal registrations under the provisions of any law under force, then we will know that they are not at least fictitious parties. Then there will be a huge gap between the value of claims received and the value of assets available, which again indicates that there is something wrong in the accounting process. Then reconciliation of financial statements with several quantitative parameters such as raw materials, freight, power consumption, gate entries. All these may be correlated to find if there are any POFE transactions. With this, we have covered all the related provisions of related party provisions in the code and under the CIRP regulations. Now I move on to liquidation regulations. So as already discussed during CIRP, liquidator has to be independent to carry the process forward. And the professionals appointed by the liquidator also should be independent of the corporate debtor and the promoters. Sufficient care should be taken by the RP apart from this taking a declaration from the professionals. And the financial creditor who's a related party cannot vote at the stakeholders consultation committee meetings. Liquidator should not sell the assets without prior permission of the adjudicating authority by way of private sale to a related party corporate debtor or to the liquidator's related party or any professional appointed by him. Usually there is an urge to sell the movable assets of the company or take away the assets. Sell the assets of the company by the to the employees, or some people may ask. So it has to be independent and sold only to non-independent, to independent persons. If it has to be done, then it has to be done with the prior approval of the adjudicating authority. Liquidator will not proceed with the sale of an asset if he has to reason to believe that there is any collusion between the buyers or the CD's related party and buyers and the creditor and the buyer. If in case the liquidator suspects that there is a collusion and ultimately the promoter or the related party is behind the transaction, then he will have to apply to the adjudicating authority and seek appropriate directions against the colluding parties. It really happens in the case of sale in an auction process, or people artificially inflate the price and ultimately they do not for some issues like that. To counter that, in case there is any issue, you have to bring it to the attention of the adjudicating authority. We move on to the order of distribution under liquidation process. Section 53 gives the order of priority. So the first goes to CIRP cost and liquidation cost, which has to be paid in full. Following that, there are two debts which rank equally. One is the workman dues for the period of 24 months preceding the liquidation commencement date, and the debts owed to a secured creditor in the event such secured creditor has relinquished the security under section 52. So here the words used are debts owed to a secured creditor. Yes, sir. So the debts due to a secured creditor is what is mentioned here. So there is no distinction between related party and unrelated party as far as section 53 is concerned. It will be going to both. Wages and any unpaid dues owed to employees other than workmen for a period of 12 months preceding the liquidation commencement date will fall under the third category. Fourth category again is financial debts owed to unsecured creditors. Here again, there is no distinction between related and unrelated party. Both fall within the same class. The following dues shall rank equally between and among the following. So here again, we have two classifications. Amount due to the central government or state government, including any fund received from the consolidated fund of India, the consolidated fund of any state, with respect to whole or any part of the period for 2 years preceding the liquidation commencement date, and the debt owed to a secured creditor for any amount and unpaid following the enforcement of security interest. And the last three legs of section 53 are the remaining debts and dues, the preference shareholders, and finally the equity shareholders or partners, as the case may be. Now we move on to the pre-packaged insolvency resolution process. So as we have seen during the CIRP and the liquidation process, the pre-pack insolvency process is currently applicable only for MSME, and it is not open for other companies at the other corporate debtors at the moment, unless they are MSME. So, pre-pack is a process by which already the lenders and the corporate debtor come to some kind of understanding on what is the payment that is going to be made. And once that understanding is reached, they apply to the adjudicating authority under the pre-pack process for approval. there is a proposal to extend this pre-pack to all corporators as well in order to simplify the process and enable more number of corporators to avail this option. And so here the approval to be taken by the corporate debtor is from the financial creditors who are not its related parties and which represent not less than 66% of the value of the financial debt due to such creditors. Only then you can file an application for initiating of the prepaid insolvency resolution process, pre-packaged. So if now the question arises, what if all the parties are related parties, then they are excluded from the process. So ultimately, they will not be able to go under the pre-packaged insolvency resolution process as a law stands today. So here again, the related parties have been clearly excluded from the process and only unrelated parties can apply. This I have completed all the aspects. If anybody has any query, I'll be happy to address.
I have one question.
Yes, please.
In the definitions, there was a mention of a related party in relation to corporate debtor.
Yes.
The director or partner was mentioned. But what if there is an association of persons, whether it is the same as partnership?
No, association of persons is not recognized form of association as far as the corporate structure is concerned, I think. Because even under the definition of person, if you see, we went to the one, let me just access it, yeah. So it is covering only individual HUF company, trust, partnership, and LLP.
Yes,
So an association of persons will not be treated as they will have to be taken independently only and seen. It will not be treated as a legal entity, is my opinion.
Okay. And if the CD itself is a part of that as AOP, then is it that to be considered as related party?
That's right. Association of persons itself is not a valid, association itself will not be a legal entity for the purpose of determining. So each one of them would have to be individually seen, as per my opinion.
Okay.
It will not be seen collectively, yes. So they have to satisfy the test of related party under the definition, whether individual or body corporate as per individually.
Okay. Thank you.
Yeah, ma'am, am I audible?
Yes, sir. Please tell me.
Yeah, ma'am, I have a question. And at first, thanks for the wonderful presentation, ma'am. So if you could kindly shed some light on IPE and the directors in the IPE and related party from the angle of taking assignment by one of the director. So if the rest of the directors, whether they are independent of the CD or FCR for that matter, OC, whoever is initiating, triggering the CIR or, yeah. Can you please touch that area, ma'am? And also, I mean, if you could summarize the discussion, like what could be the trigger points, right from say appointment or initiating the process, we need to check the related party, COC constitution, processing claims, COC constitution 29A, all these steps now. So even that could also be helpful, ma'am. Thank you.
Thank you. So as far as IPE is concerned, all the partners and directors of the IPE would have to be independent of the particular corporate debtor. So my opinion is that the larger the IPE becomes, it would be an issue because if one of them also is associated, then it would become a problem. But other than that, there is a cooling off period for the professionals. So I guess if you have not been associated for 3 years, then you would not hit the disqualification. But even otherwise, if you are remotely even related, any of the partners or directors are, it's better to excuse yourself from that assignment. To avoid any potential conflict, as you know, today all promoters and financial creditors jump at the smallest, slip on the part of the RP. So it is always better to be extra careful. And on the where in all the related party hits. So I have gone through in that order only in my presentation, where we start with initially verification of claims. There is no problem on related party, but it will hit to the extent of whether the claims are genuine or not. That is something that has to be evaluated at that time, but it would be too premature at the stage of verification of claims, because you will not be able to form an opinion on whether the inclusions in the financial statements are correct or not. So that would be too premature to reject on those basis. But anyway, we take a stand that the IRP is only collating the claims at that stage. So I feel there is no need to go into related party or non-related party at that stage. But definitely before forming of the committee of creditors, to the extent of financial creditors, it has to be done, whether it is a related party or not. To whatever extent data is available has to be analyzed, and whatever is publicly available MCA data all would have to be checked. Moving forward into the process, once the COC is formed and data is being shared, also we have said what data can be shared with the related party with the decided cases and what should not be shared. Mostly courts have allowed everything to be shared, provided confidentiality undertaking is taken. And post that, on the resolution plan, the minute the expression of interest is issued and you get the prospective resolution applicants, the eligibility under 29 capital A would have to be checked, and whether they are a related party to the management or not would also have to be checked. So that is one area which requires substantial effort on the part of the RP to check, especially when there are more than one resolution applicant. And post that, once the and also in the resolution plan, it has to be checked that none of the related parties or parties who are disqualified under 29 capital A come into the implementation or into the management post the resolution plan is approved. Beyond that, I think liquidation, again, where it is not sold to the related party or to any person who has a track record under 29 capital A. Predominantly, I think this is where we stand. As long as the COC is properly constituted and it has no related party, the court feels that the resolution process will be carried forward in a fair and transparent manner.
I have a doubt.
One question is there. In IPE, suppose all directors are there, some valuers are there. Okay. So in one CRP is we need to appoint a third representative. So we cannot assign these tasks to our directors or LLP partner in case of IP. We cannot. My question is whether these partners of the LLP or IPE specifically, all that are insolvency professionals and some valuers are there. So can I give the assignment in my one CRP case to my partners?
My basic objective of forming an IPE itself is that you provide all the services under the same banner to the corporate debtor. So as long as all the IPs are, all the associate valuers or whoever are the professionals associated with the IP are independent, then you will be able to give the assignment within the same IP.
But being a partner of I am a director also, he's also director in same IP. So maybe related to each other?
Maybe related, yes, sir, I do agree. But you mean to say you are related as a relative, or because you are just associated with the same IP?
Same, because it's associated with same IP, no any other related, not as per company, right? But being a director of the same IP.
As long as then the very purpose of IP itself is to pool in all the resources and give the services to a common, to the corporate data. So my feeling that should not affect, but anyway, I will check on that and get back to you. That one
I asked this question to one officials of the IPS. They said that we cannot. That's why I'm confused.
Oh, then I would prefer to check and get back to you, sir, on that.
Okay.
I am not part of an IP, but I will definitely check and get back to you.
Thank you.
Yeah, sure.
My name is Shivraman, ma'am. Thanks for the presentation, first of all. Very nice presented. First thing is, under section 29A, we get a declaration from the resolution applicant stating that he is not a related party to the whole transaction. To the corporate debtor.
Yeah.
Will that undertaking taken, is it sufficient enough?
Sir, several judgments the court has said that mere undertaking is not sufficient. RP will have to do some amount of due diligence and at least go through the publicly available data that is there and satisfy, the RP has to satisfy himself or herself that in principle, it is not a related party. We cannot merely go by the declaration. If there is something apparent on record, it has to be seen. Basic
That is what-
MCA data, RBI data would have to be checked.
Or, see, some of the data, for example, if I check a name of a person called, say, X,
Yeah,
if you find it that X will have legal cases against him also, when I look through a legal doc, when I look through the website of the legal.
yes.
But unfortunate enough, those legal cases doesn't connect with the PAN number of that person.
Yes, yeah. So it is very difficult to
There-
understand the name with just the name. That is what you're trying to convey. Yes.
Yeah, that is what. So what really happens is, at that moment, this undertaking comes into a play to safeguard yourself from such a situation. For example, legal cases, you cannot check it in the court of, in the website, because similar names appear for everything over there. For example, criminal cases, civil cases, whatever the thing is. Sometimes you find there are cases which are there 2 years, the adjudication has happened. All these things are there, but it is very difficult for such a situation to happen. One more thing which I find is very alarming is that the law wants the RP to have a magic wand to understand everything, which is impossible, next to impossible. What is apparent on record can be taken into consideration. And most of the times what happens is you file a Section 7 application or a 9 application. It takes at least 2 years for you to get the adjudication. Within that period of time, if the corporate debtor is very much in control, he would siphon off everything and you would be just fighting a buffet case before NCLT with no results coming out immediately.
Madam, can I ask a question?
Yes, sir, please.
Madam, during liquidation, stakeholders consultative committee, related party, what is the position, his position, whether he can vote also?
The stakeholders relationship, stakeholders consultation committee also under liquidation regulations, which is similar to the CIRP regulations, COC. It says that the stakeholders who are related parties will not participate in the stakeholders committee
Voting.
meeting.
Okay,
Similar
but they can participate, but they will not vote, correct?
Yeah, you cannot vote. Yeah, correct.
Okay, but in CRB it is there, in liquidation also it is same thing?
Yes, sir, similar provisions are available. If you see, there is reference to the CIRP regulations, which says that certain provisions of the COC will apply to the CIRP regulations will apply to the liquidation regulations. So in that, the stipulation is there. If it is a related party, then you cannot participate.
Okay, then what will be the position if they are having 40% shareholding in claims? So that 40% will be ignored, or
It will be
Like-
ignored, sir. The balance 60% will be treated as 100%.
means like 100 rupees is there, 40 rupees they are having, 40 rupees other person is having, and 20 rupees financial creditor is having. So that will be treated, 40% will be treated as
100%.
80%. 100%.
Yeah, for the purpose of voting, correct. Because similar to COC, how we do under the CIRP process, similar process, if they are related party, the same treatment is given. Because again, they will influence the process, no? So it will not be correct to have them on the committee.
Okay,
Similar
thank
provisions.
you, thank you.
Yes. There are any other questions? Otherwise, we can close the meeting. Please give me a moment. I will just inform. Anjali, are you there?
Yes, ma'am.
Hi. So I have taken up all the questions. So we are done with the presentation. Also, we can close the meeting.
Okay, ma'am. Thank you very much, ma'am. The information, the session was very informative. and February.
Thank you very much. So the second session would be at 2 o'clock.
Now we have lunch break till 2 p.m.
Okay. Thank you very much. Thank you to all the participants for the patient hearing and participating in the question answer session also. Thank you very much.
Thank you, ma'am.
Why don't we start the second session at 1:30?
Sir, at 2 p.m.
Okay, thank you.
ICSI, IIP for giving this opportunity for sharing some of my learnings with regard to the related party transaction.
ले निकालो निकालो लेके आओ आजा
Can you see the screen?
Yes.
All right.
Yeah.
Sorry, I believe it got disconnected. Sorry. Let me just reshare the screen. Yeah. So the discussion that I have divided, as I was saying that I have been doing a lot of discussions on the related party with regard to insolvency and bankruptcy code. But that discussion primarily was limited by and large with regard to the eligibility under 29A or with regard to the claims processing. The 360-degree review that Institute has attempted in the deliberation today, I think that is commendable. We'll be able to understand, and this has given me also the opportunity to analyze the role in different facets of insolvency and bankruptcy code. So we'll spend some time on the introduction part to understand why insolvency, to just set the tone of discussion today. Then we will understand what is the related party, because there are different meanings, and I'll not take you through the definition of related party under the Companies Act, but we'll restrict to the discussion on related parties with regard to the corporate debtor and the individual who is referred in the CIRP process. Then we will see the role of related party, and I have divided it into different segments. One segment is pre-CIRP era. Somebody may be interested. Before even CIRP has started, how come there is a role of a related party? But yes, there is a role of related party that is in pre-CIRP period, and that's very interesting one. And now Second bigger question that comes to all of us, whether a related party can commence a CIRP process or not. That means, can an application by a financial creditor who is a related party be admitted, or is there any judicial precedence available, or is there anything in the law that restrict? And similar analysis we will be doing for the operational creditor also, and similar analysis we'll be doing for the corporate applicant also. That is 7, 9, 10, all three application we will discuss. Now comes the main part, that once the CIRP commences, then what all provisions are there which talks about the role of a related party. There are some 8 or 10 areas that I have identified, starting from appointment of a interim resolution professional, and then appointment of a registered valuer, appointment of a professional, and eligibility criteria, and so on. Now, there are many aspects to it. Then transactions during the course of CIRP, which are called the related party transaction. What are the checks and balances? What are the restrictions provided in the code in that regard? And then we will see what is the role of related party in resolution. When a company is going through the resolution process, then what are the restrictions in respect of the related party? Then we will travel, if a company is not resolved, then obviously it will travel to the liquidation. Then in those cases, what are the restrictions or what are the roles prescribed for the related party? We will travel to that also. Is there any restriction? Especially we all are interested in knowing whether a financial creditor who is a related party will be entitled to a differential treatment in respect of receipt of distribution proceeds in terms of section 53. That would be our attempt to make analysis on the same and conclude something with help of couple of judgments. One very recent one that came on 3rd of May 2023 also by Supreme Court. Then we will also just touch upon the role of related party in a pre-packaged insolvency resolution process. And also we will see what is the role of related party in voluntary liquidation. Is there any restriction on voluntary liquidation also? And last but not the least, when we go to the individual insolvency, then in that individual insolvency, especially relating to personal guarantor to the corporate debtor, which has been notified from 1st of December 2019, what is the role of a related party? What are the restrictions? And then we will see the couple of judgments and the other issue, and we will take the question answer. I would love to be disrupted throughout the session. You need not wait for end of the session, though we will have half an hour time at the end also. I will attempt to close my discussions by maybe 4:30 or so that we have exact half an hour time available for making our discussions on the question answer. But I would prefer that whenever we are discussing on a particular subject, we make an interaction. All of you have been doing a lot of insolvency matters. Maybe you have experienced more than me what I am carrying as a insolvency professional or as a liquidator. Many of you might have done even complex assignment than what I have done. So please feel free to interject the discussion and make the value addition so that we all become richer by knowledge by end of the session that is scheduled today. We all will be benefited by this particular process. Now, when we say introduction, we all understand. I'll not take more than 7-8 minutes to go into this history because it is related to related parties. So that's why I thought I'll not skip this. I'll take this also because insolvency law took birth to overcome the issue of multiplicity. The multiplicity of jurisdiction, the multiplicity of law, the multiplicity of forums. We all know the law was scattered. There was RDDB, there was SARFAESI, there was SICA, there was Companies Act, partially dealing with winding up liquidation, and so many notifications from the Reserve Bank of India to deal with the subject of the stressed asset, leading to complexities with regard to jurisdiction, forums, and the legal remedies available to the different stakeholders. To cut that long story short, we evolved with the comprehensive framework which is known as an Insolvency and Bankruptcy Code. This was considered to be panacea for all ills with regard to the stressed asset. And that's why it was nomenclated as code as against the act, which is generally there in all legislation. So income tax is an act, Companies Act is an act, and so on and so forth. But there are few legislations which are code, like Civil Procedure Code, Criminal Procedure Code, and now the Insolvency and Bankruptcy Code. Now you can understand the importance of this particular piece of legislation. If I can give you the distinction between the act and the code. So in code, generally, it encapsulates the larger framework for each segment of society, for each kind of issues, whatever it endeavors to resolve. So is the case of an Insolvency and Bankruptcy Code, whether it is a corporate insolvency, whether it is an individual insolvency, whether it is a fast-track insolvency, whether it is a liquidation, whether it is a voluntary liquidation, whether it is a bankruptcy, whether it is a insolvency resolution for individual, everything is provided in this particular law. And rightly so, this law has non-obstante clause by way of section 238, which overrides the other laws. So objectives were very clear that we wanted to prescribe the time frame in which the resolution will happen. If not, then the time frame in which the liquidation will happen. So time is the essence, that is the bottom line. And the another important objective is to maximize the value of each and every stakeholder. The proceeds what each and every person is likely to get. And most importantly, the focus is on resolution, not on liquidation. Liquidation is the offshoot. If resolution does not happen, the liquidation is going to take place. That is how the law has created. It provides a collective platform. Somebody can say earlier there was also platforms available in the, maybe you can say Reserve Bank of India guideline, where we were doing a lot of consortium funding or the joint funding was involved in those cases also. But it was not a collective framework which was providing you the framework which was guided by the statute. In case of insolvency law, The advantage is that the rights of each and every stakeholders are written down. Each and every stakeholder is balanced through the act of checks and balances. Committee of creditor vis-a-vis insolvency professional vis-a-vis committee of creditor, financial creditor, and then both of these with the adjudicating authority, and all put together subjected to the Insolvency and Bankruptcy Board of India. So a very beautiful piece of legislation to the principles of checks and balances, where nobody is supreme. All are considered to be the important pillar, but supremacy of none of them is established. Each one is supreme in one of the act, the other one is supreme in the other of the act. I'll give you one example. Committee of creditor is chaired by the insolvency professional who has got no financial claim, but he has got no voting right. And this is so because he is one who is supposed to be the expert of insolvency and bankruptcy code, and he is considered to be fit person for the purpose of resolving the stress as per the legal mandate given by the law. Similarly, to avoid the enormous powers to the insolvency professional, the checks have been made on him also, that if he undertakes certain activities, he will be required to take the permission of committee of creditor in advance. Certain actions are required to be voted with 66% of majority vote. Certain are required 90% majority vote, like withdrawal application also. So, and similarly, there are other checks and balances also. So in net, the insolvency and bankruptcy law, which was based on the BLRC committee recommendation, made a paradigm shift from debtor in control regime to creditor in control regime. And one of the important stakeholder in this entire exercise was insolvency professional. The other one was committee of creditor. Third one was adjudicating authority. And fourth one was your regulator, that is IBBI. Rest all process as was there in the earlier regime also, that was being followed. There was not much change in that particular regard. So this law was essentially on the consolidated framework, time-bound mechanism, maximization of value of assets, promoting the entrepreneurship, ensuring the credit availability to the society, and balancing the interest of all stakeholders. So key uniqueness that this law brought was one that we already discussed, creditor in control regime. That means till the time corporate debtor is a going concern, is solvent, there is no obligation for the purpose of changing the driver's seat. But the moment you become insolvent, you are subjected to the change in the guard, and creditor in control regime takes over. Another unique feature about this law is that no court other than National Company Law Tribunal, who is considered to be the adjudicating authority, is having jurisdiction to deal with these subject matters. And third, which is the most important one, that is the non-obstante clause in regard to the supremacy of this particular law, whether it is the Companies Act, whether it is the Income Tax Act, whether it is the PMLA, whether it is any other law. Whenever the conflict will arise, the intention is that this particular law will prevail so that the stress can be removed with the very objective what are prescribed then. This law has been very quickly implemented. we all know in 2014, the process started. And in 2016, December, 1st of December 2016, the law was implemented. And this law has been quite dynamic also. And within 6 months of time, the fast track insolvency process was implemented. And in 3 years time, the individual insolvency with regard to the PG to CD has been implemented. And in next 4-5 months, the pre-packaged insolvency also has been implemented. So this is a framework where there is a super regulator, IBBI, then 3 IPAs are there, insolvency professionals are there, registered valuer are there. There are entities recognized, insolvency professional entity, registered valuer entity, and then the adjudicating authority is spread across the country in 14 cities with 28 odd benches, and one appellate tribunal having a bench at Chennai as well. Individual insolvency provisions only with regard to the PG to CD have been implemented. The law is divided beautifully in 5 parts, where each part is having a specific content. Like if you want to deal with corporate insolvency, you go to part 2, individual insolvency, part 3. If you want to deal with authorities, go to part 4, and miscellaneous part with regard to general one is in part 1, and the other miscellaneous with regard to the other things are provided in part 5. And similarly, each part is divided into some 7 or 8 chapters, and each chapter has a different content. Like if you go in a corporate insolvency, you will have a definition, then corporate insolvency resolution process, then liquidation, then fast track process, and so on. Then there are rules which are prescribed in this particular law, and as regards the adjudicating authority jurisdiction, for all the corporate jurisdictions, for all the corporate entities, the adjudicating authority is the National Company Law Tribunal, whether it is the insolvency resolution or liquidation. For non-corporate, it is it can be individual or partnership. For partnership, it is debt recovery tribunal. Now, individual can be divided into 3 parts. One individual who is doing a business, one individual who is doing a service, and the third individual who is giving a personal guarantee to the corporate debtor. Except this last one, that is PG to CD, the other 2 cases have been having a jurisdiction of debt recovery tribunal as an adjudicating authority. These cases are continuing to fall before the National Company Law Tribunal. So this is the brief background, and I'll touch upon the last slide in the introduction part, and then we'll straight come to the role of related party. Waterfall mechanism has been provided in section 53 and 178 in regard to the individual insolvency, where you have been given the cost, CIRP cost on the top of the waterfall. That means waterfall means if you are sitting on the slanted surface and water is drifted from the top of the slanted surface, the water has a tendency to go and fill the first hole first, and then it will move to the next hole. So is the these cost centers also divided. So the CIRP cost is one which is on the top of the head. Then workman dues for the past 24 months, and the secured creditor who have relinquished their security. If you have not relinquished your security, you may be having a secured security, but still you will fall in the other head, not in this head. But if you have relinquished, you will fall in the second category. Employee dues are for the past 12 months, fall in the layer 3. Unsecured financial creditor falls in layer 4. Government dues at a layer 5. for the past 2 years. Then other debt, which is like your operational creditor or the dues of workman services. Then comes your preference shareholder, and then comes the equity shareholder. Why this is essential? Because wherever you are doing the related party transactions, you are making an endeavor to maximize the value by virtue of adding something further to each and every layer so that maximization can take place. So if you are, let's say there is a undervalued transaction and or a fraudulent transaction under section 66 with a related party, and a director or a related party is asked to replenish the assets pool, then that value will add to this waterfall, and each and every stakeholder will be benefited out of this process. Now let's see what is the related party in relation to corporate debtor. So one thing before we begin, we must understand related party always has to be understood in context of some person. So first of all, you have to identify as to who is a person in whose context you are talking about the determination of related party. Because in the law, the related party is used in different contexts, and the definitions are different for different purpose. So if you are using corporate debtor in context, if you are using related party in context of corporate debtor, then the definition is provided in 5 clause 24. However, if you are trying to identify the related parties of an individual who are referred in section 29A, providing for ineligibility or eligibility of a resolution applicant, you have to apply the definition provided in section 5 clause 24A. Now, if you are using a definition of related party in relation to a company, there is no definition provided in the insolvency and bankruptcy code. What we have to do, if you go in the definition clause, the law says that for the all terms for which the definition has not been provided in this particular code, the definitions provided in the Companies Act shall be used. So the term has been defined in the Companies Act 2 clause 76, defined as a related party in relation to a company. So there are few cases we will see while we progress, that where the definition of a Companies Act will also apply instead of applying the definition of a corporate debtor. Many of the professionals are doing that mistake, that they are applying the definition of 5 clause 24, that is in relation to a corporate debtor. So definition in relation to corporate debtor is different, in relation to individual is different, in relation to company in general is different, right? So we have to be little careful as to which definition has to be applied in your particular case. Now, we need not learn it, but definitely it will help if we are at least able to run through the definition, just to give you the mind as to what all kind of people are covered in the definition of a related party. Now, this first category of related party in relation to the corporate debtor, it will include the director, and if it is a limited liability partnership, then it will include the partner, then relative of director, and of course the relative of partners. So director, designated partner, partner of company or LLP, and their relative. This is first category. Second, the key managerial personnel or their relatives of a corporate debtor. Then there may be a possibility that director is a partner in the partnership firm or limited liability partnership. So such limited liability partnership or a partnership firm will also be considered as a related party. And it includes the limited liability partnership or partnership firm where relative of a director or partner is also a partner. Fourth category is a private limited company in which the director or partner or manager is a director and holds along with relative more than 2% of its share capital. This is same definition what we have learned in 2 clause 76, only minor changes are there, few things have been added. Similarly, a public company, if it is a public limited company, if you are testing from corporate debtor perspective, then public limited company in which the director along with the other director and relative hold more than 2% of paid up share capital. Then any body corporate whose board of director, managing director, manager in the ordinary course of business is acting on the advice, direction, instructions of a director. Now, in this particular point, many of the professionals are taking a view that just because the other entity is subsidiary, the holding company is considered automatically as a related party. Maybe otherwise it is a related party, but maybe it is not on this particular ground just because of this relation, unless and until whether this clause F, they will not fall. They may fall in the other category. Unless and until you have some evidence with regard to the agreement, with regard to the conduct that the directors of that other entity are acting on the advice or directions of the people involved in the corporate debtor. Similarly, a limited liability partnership or partnership firm whose partner or employee in the ordinary course of business act on the advice, direction, instructions of a director or partner. Similar provision as was there in F, now it is in case of a LLP. Then another category comes accustomed to it. Any person on whose advice, direction, instruction are director, partner, manager of a corporate debtor. That means it's a shadow director kind of situation. Now in the Companies Act also, there is no concept of shadow director directly, but indirectly in form of 2 clause 76, they have included this particular condition, and those will be considered as having a relation, and they will be considered as a related party also. Similarly, a body corporate, which is a holding, subsidiary, associate, right? So these peoples will also be covered in the definition of a related party. Now, then comes category, any person who controls more than 20% of the voting right of the corporate debtor on account of ownership or voting right. So if you are holding just a 20% voting right also, then even that entity will be considered as a related party. Any person in whom the corporate debtor controls more than, or if you already if your corporate debtor controls more than 20% of the voting right, then also that entity will be considered as your related party. Then it comes where says that any person who can control the composition of board or corresponding governing body of the corporate debtor. So that will also be covered herein. Any person who is associated with a corporate debtor on account of participation in policy making process, having more than 2 directors in common between the corporate debtor and such person, and interchange of managerial personnel between the corporate debtor and such person, and the provisions of essential technical information to and from the corporate debtor. So this is the last clause which is not there in the Companies Act definition of 2 clause 76. So this is an addition. So you have to work bit more in case you are identifying the related party in relation to a corporate debtor under the Insolvency and Bankruptcy Code. So there are a couple of clauses which you will be required to travel again, and in addition to what is prescribed in the 2 clause 76 of the Companies Act. Now, similar definition is there in relation to an individual also, but let us read it out. So while we will be making an application, we'll be able to recall as to whether these clauses we have read therein or not. Now, any person who is a relative, very natural. If I am a Amit Gupta is an individual, so whosoever is a relative or relative of spouse, my definition, the definition of relative has to be applied on me individually and has to be applied on my spouse individually, right? So there will be a complete chain of some 15 people on my side, and then complete 15 people chain on the my spouse side. Then a partner of a limited liability partnership or a limited liability partnership or a partnership firm where I am a partner. So if I am a partner, let us say in ABC LLP, where 2 more partners are there, B and C. So Amit is definitely a person in whose respect we are trying to identify who are the related party. So person B and person C, then ABC LLP are to be considered as a related party of mine. Any person who is a trustee of trust in which the beneficiary of the trust includes the individual, or so if, let us take the example, if Amit is a beneficiary, so whosoever is a trustee in that trust will also be considered as a related party. Or the terms of trust confers a power on the trustee which may be exercised for the benefit of individuals. So concept is that if directly, indirectly, I could be the beneficiary, so whosoever are trustees of that trust, they will automatically be covered in the definition of a related party. Similarly, a private company in which I am a director and hold along with relative more than 2%. Simpliciter director not having any shareholding will not tantamount that private limited company as being considered as my related party. Similarly, a public limited company in which the individual, that means I am a director, and along with a relative I hold more than 2% of the paid up share capital. Then the body corporate whose board of director, managing director, manager, in the ordinary course of business act on the advice, direction, instruction, same clause as we discussed in the previous definition. Similar, again, in respect of the limited liability partnership. Then again, the clause regarding the accustomed to act. If I am accustomed to act on the instructions of someone, that person will also be included. Then a company where the individual or the individual along with the related party own more than 50% of the share capital of the company or controls the appointment of the board of directors of the company. Now, if you go in this particular clause where you are saying that a company where individual along with its related party. So individuals related party are again as per 5 clause 24, except this particular clause, you will consider A to H for the purpose of applying that definition. If I along with any of those people hold more than 51%, then that company will be considered as a related party to me. And then definition will be definition of relative. If you talk about, then it is clearly defined that members of HUF, husband, wife, father, mother, son, daughter, sons, daughter and son, daughters, daughter and son, grandsons, daughter and son, granddaughters, daughter and son, brother, sister, brother's son and daughter, and similarly sister's son and daughter, father's father and mother, mother's father and mother, and so on. The point that I am trying to emphasize is this definition of relative is larger than the definition of relative provided under the Companies Act, where the relationship is very short. The relationship is very straight, that you have to see left, right, up and down. Now, more or less, that covers the lineal ascendants and lineal descendants, left and right. Those are the people which are covered in the Companies Act. But here you will see it is more than 2 layers of a lineal ascendants and descendants, and many other categories of peoples have also been included. So be little cautious when you are examining, especially from 29A perspective. When we'll come, then I'll show you one chart that I have prepared. How many people can get covered in this particular definition. Now let us go further and understand the role of related party during the pre-CIRP period. Now, pre-CIRP period, when we talk about, somebody can say my CIRP started on 1st of January 2023. Then why should I be bothered that what a related party has done prior to commencement of CIRP? Answer is no. Because if you recall the PUF transaction, the avoidance transactions, which are encapsulated in section 43, 45, 50, and 66. 43 is a preferential transaction, 45 is undervalued transaction, 50 is extortionate credit transaction, and 66 is fraudulent transaction. And all of these clauses specifically differentiate with regard to applicability when the related party is being dealt with. So that's why it becomes important if you are the look back period, whereas in ordinary cases 1 year. In all these cases, of course 66 is an exception, in all these cases the look back period is just double, that is 2 years. So if you have done a preferential transaction, let us say the CIRP commenced on 1st of January 2023, and if you have done a preferential transaction with unknown person, and that has been done, let us say prior to 1/1/2021 or 1/1/2022. If it is prior to 1/1/2022, it is out of the ambit of radar of preferential transaction, because it is only talking about 1 year prior to commencement of CIR. However, if it is a preferential transaction with a related party, and related party, you know whom we are talking about, because we are talking about related party to the corporate debtor, the entity that has gone into CIRP. In relation to that, we have to see who were your related party at that point of time, and you will identify whether they are hit by this particular provision or not. Now, another important point to ponder in this particular law, just think over what is the time frame in which you have to apply the law or apply the test. You will apply the test of related party in today date, or you will go back in flash at that point of time, whether it was a related party or not. To my mind, in rest of the places, it has to be current. Like if we talk about 29A, maybe a person was related party, but he is not related party today, then I am safe. Then the resolution applicant is not disqualified, because the word used is in present tense. Whereas if you go in section 43, 45, 50, 66, I could not find out anywhere. The context gives me the understanding that it has to be seen at the time when the transaction was done. So if I have to look back 2 years prior, I have to see the relationship at that point of time. If a transaction was related party with related party, maybe the person has ceased to be the director today, but he has done a preferential transaction. He has done a preferential transaction and gone away from the company. Are we saying that we cannot touch him? He is becoming untouchable. Answer is no, because that will lead to absurdity. The entire purpose of avoidance transaction will go away. So for this purpose, now let us keep in mind that for avoidance transaction, the time frame in which you have to test the related party relationship is the time when the particular transaction has taken place, right? In other cases, generally, I'm saying in 29A or the eligibility criteria or the appointment of IRP, everything has to be tested on the current date. So this is a point of distinction in relation to the other things. Now, what is the responsibility of a RP or IRP? RP or IRP as per section 25 of the Insolvency Code are required to file an application for the avoidance transaction. When they are required to file? They are required to file an application within 115 days. The timeline is very, very critical in insolvency and bankruptcy process. We will see there is one specific slide, but for the moment, the obligation is coming from section 25. Similar obligation is there on the liquidator also in section 35 and 35A, which provides for the model timelines. We also need to understand what are the timelines provided therein. And now when you submit a resolution plan, regulation 39(2) comes into picture and cast an obligation to provide some information with regard to the avoidance transaction also. You have to make a declaration whether any application is pending there or not. So it is very important for us to understand that how pre-CIRP period related party transactions are important for us to understand. Now, what I was saying, on one hand, you have a different timeline. Different timeline is that you have been appointed as the IRP. In 3 days time, you will make a publication in the newspaper. You will be appointed, you will be getting a claims. In 1 week time, you will process the claim. You will finalize the list of committee of creditor. Within 30 days, you will hold your first meeting, right? And you will appoint the resolution professional and submit the application to adjudicating authority, and adjudicating authority will complete that. Then you will make the appointment of a registered valuer. Then you will be preparing your information memorandum. Then you will be publishing the expression of interest, and then Form G, and so on. The process will go on. Simultaneously, you are casted an obligation to make an opinion within 75 days from commencement of CIRP as to whether there exists any PUF transaction or not. Now, how you will form this opinion? This itself is a complete session. I will not go into detail, but I will give you the indication what you are expected to do. That you have to understand the red flags. You have to understand what are the gray areas that you have noted. And this is no separate process, because your priority is to keep your CD as a going concern. Your priority is to appoint the valuer. Your priority is to deal with the stakeholder. Your priority is to complete the CIRP as per the mandate in the law. On the parallel, you are being mandated, you please do inquiry. You please keep identifying what are the red flags. And the red flag could be you are not provided the access to the registered office. You are not provided access to the books of account. You are not provided the financial statement. You are not provided the position. You are seeking no management cooperation. You are not getting any cooperation. Your 19(2) application is pending, and so on and so forth. While review of the financial statement, you are able to find out that there are prima facie defects. There is a rampant change in KMPs. Your CFO is resigning every 3 months or 6 months. Your company secretary is resigning every 3 months, 4 months, 6 months. So these are all indicators. These are all red flags that there is something fishy. You need to deep inquire. So how you will frame the opinion? Opinion is more than suspicion. So first step will be suspicion, that you suspect. Suspicion will come maybe from media report. Suspicion will come maybe from the person who is giving you the information, maybe your employees, maybe the other people in and around, maybe the creditors. So there will be suspicions on the basis of some feedback, maybe some document, maybe some information. On the basis of that, you will do some preliminary check. And on the basis of preliminary check, you will frame your opinion that there are existence of some prima facie transactions with regard to which are hitted by the preferential transaction, right? So you will just list out all the transaction. How you do actually? What we do, we create an Excel file, and whenever each day basis the team keeps on working, they insert the date, they insert the relevant facts, and they insert the timeline that these discoveries have been made today. And we keep on adding that maybe some immovable property was transferred to someone. We got to know today. We were making a review of balance sheet. We got to know that some money has came instead of to company, but gone directly to settle some creditor. That is also some inventory has been sold to the director at a price lesser than market price. So you will keep on building and scanning these information over a period of time, and you will be able to form your opinion whether this exists or not. Now you get another, you can say 40 days time to make a determination. Now how you determine? Determination is to collect the evidences. Now you engage the transaction auditor, you engage the forensic auditor, or you yourself do that exercise of identifying what are the preferential transaction, what are the extortionate credit transaction, fraudulent transaction, and so on. It is not necessary that you have to appoint forensic auditor. If you are capable, you can do on your own, depending on size of the organization, size of the CD, complexity involved, you can take your own call. Now, next in 20 days time, you are required to file your application. Your one hand, your process has to complete in 180 days. On the other hand, you are running a timeline that in 135 days, you have to file the PUF application also. Otherwise, it becomes time barred. Though it can be admitted, there are many cases which are suggesting that if you have a reason to justify before the adjudicating authority, they will admit. Then RB has the obligation also that whenever you are submitting a resolution plan, therein you will specify which all applications are pending, what all observations had been made, and a certificate is also required to be given in the Form H while you submit that. Similar responsibilities are also casted in respect of the liquidator. I'm not repeating the same. This is also, we have discussed whether the transaction auditor is required to be appointed or not. What could be the fees? If somebody asks me, I will say, yes, we should take the committee of later into the confidence, because ultimately the fees that we propose to pay to the transaction auditor is required to be approved by them. Now, the task that we have today is to understand how the related party and other than related party are different in respect of PUF transaction. If you are finding out a preferential transaction with an unrelated party, then the look back period is only 1 year, as I gave in the example. But if you are dealing with a related party, then the look back period is longer, that is 2 years. Now, what is the preferential transaction? Because we are discussing, let us understand that also, otherwise it will be just a superficial survey of a related party, will not be able to do justice with the subject. So for preferential transaction, there are certain conditions to be fulfilled. A, there has to be a transfer of property. Now, property means what? Property means money, property means goods. Actionable claim, that means if you have a stock in trade, if you have a immovable property, if you have a receivable, if you have land, every description of property will be covered in the property. So there has to be a transfer of property. So transfer of cash, because money is also included. So if I pay somebody money also, that is also a transfer of property, mind you. Or transfer of interest of CD. Now, interest means what? Every description of interest, whether it is present, future, contingent. Means if somebody has got any leasehold rights, that is also an interest, and that will be well covered in the transfer of property. Now, transfer should be made to 3 people, any of the 3. Either it should be made to creditor, or to some surety, or to some guarantor. Now, third important condition, the payment is made on account of some antecedent. Antecedent means pre-existing. Antecedent financial debt or operational debt or some other liability. Antecedent, matlab, there should be a liability in existing. Now, let me give you the example, how it can happen. Let us say Amit Gupta is a director of IBC Limited that has gone into insolvency. And I have given a loan of 1 crore to IBC Limited. So that means there is an antecedent financial debt in IBC Limited. Now there is a company, the real estate, and company built the flats. Now what company did? Company transferred the ownership of one of the flat whose value was, let us say, 1 crore. 1 crore value of flat was transferred to me to set off the loan liability. That is what is envisaged so far in the condition. A, there has to be a transfer of property or interest. The transfer of property should be to the creditor, to the surety, or to the guarantor. Third, the transfer is in respect of some antecedent, either debt, financial, operational, or other liability. Then fourth condition is also very important, that it should be impacting the waterfall. That means the moment the payment was made, if you map it in 53 section, the priority order is going up. Whereas if I have given a financial debt, I was otherwise falling in a category 4. Now, what has happened? Bypassing all other category, I have made the repayment to Amit Gupta. So that means the fourth condition simpliciter says, if by making this payment, if by making this transfer, you have a change in waterfall mechanism to move the person to the upside in the ladder, then fourth condition is also fulfilled. Then you consider that this is the preferential transaction. As simple. Only 4 conditions are required to be fulfilled, and if you are able to prove this to the adjudicating authority, you are done, and the preferential transaction will be proven. The condition is that if a transaction is with a related party, so all related party transaction 2 years up to the commencement of CIRP will be captured in this particular category, and they will be what kind of relief you can have. The relief will be that this Control Z can be pressed, the entire transaction can be reversed, the property can be brought back to the company. Whosoever has bought the property, he can be asked to make good the money, whatever is taken out of that property, and whatever you can think of the order for the purpose of bringing the parity with the corporate debtor, those kind of orders can be passed. So ultimately, it is in the interest of corporate debtor that we are able to do that. The only point that is relevant in regard to the related party is the look back period is 2 years. I'll not go deep into the subject. If anybody has got any question, then we will take it in our question answer. What is protected is if a transaction is in good faith and it is an ordinary course of business. So if I have sold one property in ordinary course of business, I don't know whether the company tomorrow will go into insolvency or not, but I have sold that property and inventory has been, that is also a transfer of property and maybe to a related party also. But if it is in ordinary course and in good faith, so that is what is the important test that has to be proven, that why that necessity arisen for the purpose of, then that transaction is out. Otherwise, these transactions will be covered in the preferential transaction category. There are many examples, and while I'll be sharing, one example that I have given already, that I have given unsecured loan, and instead of making the payment to the other financial creditor, the payment has been made to me by way of transfer of property, or maybe my payment has been made in hard cash, does not matter because money is also covered. So if a preferential treatment is done to me, then it is a preferential transaction. Whether it is in form of a cash, whether it is in form of a transfer of property, whether it is in form of transfer of some asset or whatever. Right? So these all examples will fall in the category. And one more example could be that ABC Limited has to recover 1 crore rupees from Mr. A and has to pay 1 crore rupees to Mr. B, who is a sundry creditor. So instead of receiving money in entity and routing it through the bank account of the company, what ABC Limited did, they asked A to pay directly to B. That is also a preferential transaction, provided those 4 conditions are fulfilled. Right? So there could be many. Another example could be that Amit has given a property as a security for securing the loan to the ABC Limited. Now, this loan has been repaid. Somebody can say, where is the problem? Bank loan has been repaid, but bank loan has been repaid to get my property released. So my personal property has been set free, whereas the other loans continue. This will also be considered as a preferential transaction, provided it qualifies the 4 conditions that we have discussed. Now, there is a very interesting judgment of JP matter. In this matter, Supreme Court, as you are aware, that Jayaprakash Associate Limited obtained the funding from the consortium of bank and the institution, ICICI Bank, Standard Chartered and State Bank, and security was provided by JP Infratech, that land that it was owning. Now IDBI Bank, who was a creditor, filed a Section 7 application against JP Infratech. Loan was taken by whom? Loan was taken by Jayaprakash Associate. Mortgage was created by JP Infratech because properties or land was belonging to them. Company that went into CIRP was JP Infratech, and 9th August the CIRP commenced. Now what happened? When claims were filed by the lenders of Jayaprakash Associates Limited, because they have lent the money, on the strength, the loans were rejected, the claims was rejected by the IRP, that the mortgage created by JP Infratech as a collateral security of debt of its holding company, that is Jayaprakash Associates. NCLT held certain transactions by which corporate debtor, that is JP Infratech, had mortgaged the property as collateral security as being a PUF transaction, that is 43, 45, 66, all were alleged. Now, NCLAT on 1st of August 2019 set aside the NCLT order and allowed the lenders of Jayaprakash Associate Limited to be a financial creditor of JP Infratech. However, the entire NCLAT judgment had been only in relation to the NCLT order dated 16th of May 2018 for the avoidance transaction application filed by the IRP, and no reasons were given for reversing the order dated 9th of May and 15th of May 2018. The appeal from NCLAT judgment went to Supreme Court, and Supreme Court, while deliberating, framed few questions, and very interesting one. Whether the mortgage transaction in question deserves to be avoided as being preferential, undervalued, and fraudulent under section 43, 45, 66. Or could the Jayaprakash Associate lenders be recognized as a financial creditor of the corporate debtor, that is JP Infratech, on the strength of mortgage? Whether the mortgage transaction by JP Infratech in favor of the lenders of Jayaprakash Associate is a preferential transaction. Now, what was the observation? The important finding, I think that is the learning for all of us, and that learning came as early as in 2020. The learning is that the scope of inquiry under preferential transaction in section 43, undervalued transaction in 45, extortionate credit transaction and fraudulent transaction is altogether different. So don't make a common application. The majority of the people that are filing the PUF application, the mistake they are doing is they are making one common application. In that, allegation is that either this transaction is preferential, or it is undervalued, or it is extortionate, or it is fraudulent. That is where the problem arises. Because you yourself are not sure, after doing so much of inquiry, how the adjudicating authority will be able to pass the order against anyone. That is what precisely the Supreme Court observed. They said you should make the separate application as to whether the transaction falls in a preferential transaction or not. Then only you will be entitled to a particular relief. And they also gave a guidance. I think in this discussion, I will add to that particular methodology also, which is very interesting one for all of us. They gave the methodology as to how you will identify whether the PUF transaction exists or not. They mentioned that you will scan all the transactions relating to property, interest, backward from the insolvency commencement date up to maybe 2 year, 3 year, 4 year, right? Whatever reasonable period you consider. Then you will do the filter as to who is the person involved. Then you will identify whether the person is a related party or not. Because it is not possible that you will identify who is the related party and then you search. It will never work. You will never be able to succeed. So what all you have to do, you have to just write down all the transactions that have taken place in the last 3 years or 4 years time. And then you see whether the people are involved, whether they are related party or not, by applying the definition of a related party, 2 clause 24, 5 clause 24. Then those who are in related parties see whether it is falling in the look back period of 2 years or not. If it is other than related party, whether it falls within 1 year or not. Then you see whether the conditions of preferential transaction or conditions of undervalued transaction or extortionate credit transaction or the fraudulent transaction are fulfilled or not. If yes, you prepare your application, file your application before the adjudicating authority, and you will succeed. Similar observation was there in the KL Jute product also. I'm not repeating, but a similar, very similar observation in this matter also. Vital essay, Abhishek Nagori also, it talks about whether the what is the time period with regard to this. I'll not touch upon these, but let me come to the other important aspect with regard to the undervalued transaction. Now, in case of undervalued transaction, just what we have understood in case of 43, here preference is not there. If I do a transaction at a price which is less than the fair market price, it is undervalued. The look back period remains same. If it is other than related party, 1 year. If it is related party, it is 2 years. Now, interesting point is here the application can be filed by the creditor, member, or partner of the CD also if IRP has not reported this transaction. Whereas for preferential transaction, he has no power. But for undervalued transaction, the danger is more for the RP or liquidator because the power has been given to the other people also, that is creditor, member, owner as well, for the purpose of doing that. Now, where it is a transfer of asset or one or more asset for a consideration which is less than the value of consideration which is provided by the corporate debtor, and this transaction is not in the ordinary course of business, the independent valuation may also be required by the adjudicating authority. This will be simpliciter or undervalued transaction. Now, let me give you the example of undervalued transaction. Very simple example is that you will correlate that as soon as CIRP process is about to commence. Normally you know that it takes about a year or so in average to start the CIRP process admission, right? Nowadays, that is the trend. Even in many cases, it is even more. So as soon as you know that there is no possibility of recovering from this point, this is the point of no return, the management starts transferring the high value assets in the name of their related party in the back date, or maybe in the current date also, but they try to do it in the back date. Maybe let us say I am owning one BMW. Maybe value is 1 crore. Book value is coming 20 lakh. I am doing a transaction at rupees 20 lakh, but the fair value still is 50 lakh. Undervalued transaction. I am having one flat. I know I will not be able to revive. I transferred it at my book value to one of my relatives, so that the RP, whenever it comes to take the possession, is not able to take possession of this asset. I am having other luxury goods or office equipment. I am siphoning off those assets, maybe free of cost or at a nominal value. So these are all examples of the undervalued transaction. Control Z button can be pressed here also by the adjudicating authority. And interestingly, if you don't do the filing of this application, Section 47 gives a power to the creditor, to the member, to file an application, and in that case, IBBI can even ask an inquiry against you and set up a disciplinary proceedings also against you to protect the interest of the other stakeholder. Another very interesting example that we noticed in one of the case, that purchasing the assets at a high value is also undervalued transaction. Very unique innovation was done in one of the matter where company was having huge cash. What they did, the promoter was having some idle land which was having some dispute also. So the company acquired that land at 10 times higher price than the market price. So if the land was, let's say, valued at 1 crore, they paid 10 crore rupees against purchase of that land from the promoter. So ultimately that is also undervalued transaction if you see it from the other perspective. Similarly, if you transfer the goods franchisee to the other person, now value of which may be lower, transfer of shares of subsidiary company, very common example. As soon as CIRP is going to commence, the promoter start transferring so that the control is not on those assets, right? So if it is with a related party, this will always be a related party transaction in majority of the cases, mark you. Transfer of brand, ownership, copyright, very common example. There are n number of examples you will find out, which you will be able to correlate with your cases that you have done. Now, third is the extortionate credit transaction. Now, what is the extortionate credit transaction? That CD is raising the financial or operational debt during the 2 years preceding the insolvency commencement date. The terms of which are requiring the CD to pay the exorbitant payment, and terms are unconcessible under the principles of law relating to the contract. So you are charging, you are agreeing to take a loan at a interest rate of 36%, 38%, 3% per month, 4% per month. When you know that there is no possibility of return, no possibility of revival, still you are taking, again, these kind of transactions can be set aside by the adjudicating authority, which have been done, and the undo button can be pressed in this particular case also. Now, last one is a fraudulent transaction. Now, where fraudulent transaction means where you are what are the transactions with intent of defrauding the creditor? Business of the corporate debtor has been carried out with the intent to defraud the creditor or for any other fraudulent purpose. When the transaction has taken place before insolvency commencement date, when director knew or ought to have known that there are no reasonable prospect of avoiding the commencement of corporate insolvency resolution process in respect of such corporate debt. Now, director or partner, if they have not exercised the due diligence in minimizing the potential loss, then they'll be guilty of the fraudulent transaction. And the adjudicating authority may direct the director of corporate debtor to make good loss. This is the only, of the 4 transactions, this is the only transaction where a director of a corporate debtor is asked to replenish the money or bring the money back, whatever loss the company has suffered, because this is a fraud. And there is no look back period, whether it is a transaction with related party or other than related party. If it is a fraud, maybe 5 years early also, if this transaction has taken place, then this can be covered in the this particular fraudulent transaction. That's how we understand the concept of PUF transaction. There are certain punishments provided for the director and other thing, but what ultimately we are achieving out of this fraudulent PUF transaction is, if we recall the 53 waterfall, the resolution plan will be providing something how to deal with the PUF transaction, where the value will go, whether it will go to financial creditor or it will go to resolution applicant who is a successful, or it will be dealt in other manner, but ultimately it is going to benefit to one or the other stakeholder for the purpose of maximization of value of the assets that we have talked about. Let us move to the next role. If anybody has got any question, maybe we can deal now only, or if there is no, then we will move forward. Up till now, if there is any point for discussion, let us take those questions.
Sir, you said that separate application for made to all the sections and separate application to be made for all 66 and other application. But
Your
recently,
voice is very low. Can you be a little louder?
you said that the separate application need to be made. for
Separate
all
application, you are asking whether
for transactions, for different transactions, you are so as per a 24th April judgment, NCT said that we can make a one comprehensive application. Is it correct or not?
so if somebody is able to hear, can somebody
He's saying there is a judgment of 24th April, which says that combined application can be made in case of all these this thing.
So
Okay.
even in JP matter also, what the Supreme Court observed, that they have not mentioned that you cannot file the single application. What they advised, why they advised in Supreme Court in JP matter, they mentioned that the scope of inquiry of each allegation of preferential transaction, undervalued transaction, fraudulent transaction is different. So if you are making one single application, but you are making a compartment that this transaction is an avoidance application. This is a preferential transaction, and you prove and you make a prayer. Then you make that this is the undervalued transaction. Then you make prayer, then you make the application. Likewise, you do the compartmentalization, that is okay. But if you yourself are not very sure as to whether this will fall in a preferential transaction or undervalued transaction, maybe it is possible that it can fall in both, that it is the undervalued as well as preferential. The same example that where I have given an unsecured loan of 1 crore and company has transferred me the flat of 5 crore against the settlement of 1 crore, then this is a preferential transaction as well as undervalued transaction. So it is possible in certain cases that more than one category are also involved, but generally it will not be in all cases. So if you make your factual presentation, after that you say you pass appropriate order under 43, 45, 47, 50 and 66, that is not correct to my mind. What I understand from the recent order also is that there is no prohibition. Law does not compel you to pay separate fees for filing separate application. Law only requires you that you should make your case separately because the scope of inquiry is different. I hope I am clear.
Yes, sir. Thank you. Only in addition to this application, in addition to further whether the transaction audit report is sufficient for evidence, or we have to add additional evidence also for the application?
So transaction audit report, I have not dealt much, but let me give you a clarity. So transaction audit report is not necessary in all cases, but the cases where the value is very high, where the complexity is there, where you are not yourself able to do the analysis or corroboration of the fact, because it's a very, very Herculean task, because you are given very limited set of information, you are given a very limited factual statement. On the basis of that, you are corroborating to reach to the finalization of a view, right? You are determining whether a fraud has taken place or not. So you need to have evidence. So unless and until I don't appreciate a report of transaction auditor which is inconclusive. So instead of that, I will prefer that you better not have the transaction audit report as a part of your application of PU. Because in majority of the cases, in my last 6.5 years of experience, I have observed, I have defended as many as 5 or 6 PU cases successfully. And the reason was that not I was having a case in merit in my favor, but because the other person, the resolution professional who had prepared the application, he has been inconclusive in the transaction audit. He has been inconclusive in the application. in many of the application, he has pleaded before the adjudicating authority to allow him to do the further inquiry by SFIO so that the facts could be digged out. That is not the scope of transaction audit. If you are not able to conclude anything, then you are gone. In 43, 45, you cannot make a prayer for investigation by some CBI or SFIO. If you are doing that, means you are diluting your application. So if you are going with inconclusive audit reports, transaction audit report, then I feel that it is not required. One more last question, I think, which is generally asked. Should I share the transaction audit report with the promoter or the person to whom I am making the allegation? My view is that yes, you should share. There is no harm, because ultimately once you file the application, you will in any case be providing that copy to him so that he can defend the matter. What is the harm that if you provide, at least we are doing, what is the advantage? Advantage is that we have his version in advance. I know what kind of counter he is going to make in the NCLT tomorrow. So I am better prepared if I send a copy to him or limited extract out of him, asking him to explain what is his version. So A, I will be better educated. B, I'll be better prepared. C, I'll be better represented during the course of argument that I'll be having in the adjudicating authority. That's it. Yeah.
Thank you. So if transaction audit is conclusive, additional evidence need to be given or not? That is simple. Last question.
Conclusive?
If a transaction audit report is conclusive one, it is not.
Definitely you should give. I'm not saying you should give. It adds a value to the whatever application you are making, right? Definitely it should be given. But I'm saying ki you need to discuss with the transaction auditor also. Boss, you don't please give me inconclusive report. Whatever way you conclude, either the fraud has taken place or not taken place. In absence of information, if you keep it inconclusive, then it is of no use for me. Better I not file the application at all, right? It is not going to help you. But filing or non-filing is a different matter, because in 47, the member or creator also has got a right. So in certain cases, we are compelled to file, right? We don't have a choice. So that's a different matter. But yes, we should endeavor. The time has come when the forensic audit ultimately has to evolve with a limited sense of information, how to draw the inferences, how to corroborate, how to come to the conclusions. I think that is the art that the forensic auditor need to develop. We still are in a very nascent stage, if I can say so, because this I am saying with full responsibility, because I am aware of the number of cases of youth application which have been successful all across the country. They can be counted on fingers. They are not many numbers, right? So, and reason is very simple. It's not that many applications are not filed. Many applications are filed. They remain inconclusive. They remain unheard. The force is not there. And also because after the resolution plan is approved, there is no owner of these applications. That is also one of the prime reason of remaining these applications as pending. All right, I think we can now move to the next point with in relation to the related party. Now, important question that comes, whether a related party can initiate the CIRP process. Now, if I, as a student, I have also not examined. First time I am examining it from this perspective, especially when I am asked to. If I read section 7 or 9 or 10, what section 7 says? My attempt was to identify whether there is any qualification or observation in that regard, or is there any judgment? That is what I tried to find out. And section 7 simpliciter says a financial creditor, either by itself or jointly with other financial creditor or any other person on behalf of the financial creditor as may be notified by the central government, may file an application for initiating CIR against the corporate debtor before the adjudicating authority when a default has occurred. So The conditions are that default should be there of minimum amount a financial creditor can file. Now, there is no bifurcation as to which financial creditor can file. Now, if I am a director of a company and if I have given an unsecured loan, can I initiate the CIRP process against the corporate debtor when I am having liability?
Yes, you can.
Yeah, answer to me also comes to yes. If I am
But
obviously there is
But the,
no.
que-
Yeah.
but the question is, will you spoil your own company going into
No,
CIRP?
no, sir, I will say, Mr. Shivaraman.
Sure, Raman.
Yeah. So what I am saying, we should not look it from that perspective, because why I am saying CIRP is a spoiling, because I consider that CIRP is a process where you are giving medication. CIRP is a process of treating you in a ICU where you are having a disease. Let us say I am having a disease of cancer. Now, whether I my own go to doctor to ICU or you take me to the doctor, how does that matter? Ultimately, treatment of Amit Gupta is required. If I am suffering from cancer, there is no reason why I cannot go. That is the fundamental premise on which we are starting the discussion. Let us see how it ends, right? So definitely there is no barring on section 7 application. Same case, it is no barring in section 9 also, because the wordings are very clear. I can file the application. Now, when it comes to section 10, now section 10 says who can file the application. That is, I, corporate debtor, myself also can do that application. This is the answer to Shivraman sir when he is saying that why at all I will go, because that is the scheme. Who bells the ring is not important. If you have a disease, the law itself has provided that corporate debtor himself can go and get himself treated if he know that he is suffering from a cancer. Now, interesting is, if you see the definition of a corporate applicant, the corporate applicant means section 5 clause 5 has defined, means a corporate debtor or a member of a corporate debtor who is authorized to make this application, or an individual who is in charge of managing the operation and resources of the corporate debtor, or a person who has a control and supervision over the financial affair of the corporate debtor. Now, these are all different category of people. That means a corporate debtor, by passing the resolution that we want to initiate the CIRP process in terms of section 10, I can go, or the person who is managing director or managing the affair, or the person who has a control. So the law itself in the category of a corporate applicant has provided that you can go in a bona fide manner, not in the manner in the malicious. So if you have an intention that you want this application to be filed, if let us say I take the same example where Amit Gupta is a managing director of IBC Limited, and Amit Gupta has provided the credit facility also. Let us say 1 crore rupee loan I have provided, and that is in default, and I am not able to pay the bank loan also, right? Now, if at all I think that I need to file the CIRP against IBC Limited so that this can be revived, then I can always go in section 10. Why I am initiating the application under section 7? That is the important question that will be faced by Amit Gupta when he files the application under section 7 of the insolvency. Now, on top of it, when you see the provisions of section 65, which says that if any person initiates the insolvency resolution process or liquidation process fraudulently or with malicious intent for any purpose other than for resolution of insolvency or liquidation, the adjudicating authority may impose such a person a penalty which shall not be less than 1 lakh rupee or which may extend to 1 crore rupee. And similar provision exists for PPIRP also. That is pre-packaged insolvency resolution process. So in general, if we want to conclude, yes, there is no restriction. 7, 9, 10 are open. One can go, even if it is a related party, one can go. Even section 10 directly provides that a related party can file the application. And I would quote one judgment, very recent one, where the matter was decided by appellate court in the matter of Zoom Communications Private Limited versus Par Excellence Real Estate 2022 judgment. In this matter, a loan of 7 crore was obtained from Indiabulls in favor of corporate debtor. The document was screen shared by the counsel in the corporate debtor. And he pointed out that loan was applied by the corporate debtor and the co-applicant was some Mr. Gulshan Jurani, who was the director of the operational creditor. Now, section 9 application was filed claiming that debt of 57,25,000 is due, which was the process fee for the procuring the loan from the corporate for the corporate debt. Now, adjudicating authority, naturally, after hearing and finding out that there is a co-applicant, there is a fee, transaction fee, and the dues are on account of the transaction fee, dismiss the application for commencement of CIR. Matter went to appellate court, and now appellate court not only affirmed the view of adjudicating authority, but also directed to issue the show cause notice under section 65. So that is what I was talking about, the malicious application. So wherever the related party or the applicant is filing the application with a malicious intent, the burden is on him to prove that this is not malified application, but otherwise in general there are cases where the applications have been admitted also, and section 10, many examples are already in existence. I think by and large we all know, so I have not dealt into that separately, but there are many orders which are available. In respect of other cases, I could not find out many orders, but if somebody is having, then you can share in the chat box for the benefit of the members.
Sir,
Now,
in such cases, what is the role of IP who has given consent for remaining IP in such matter?
see, there is no difficulty. You have to assume your role as an independent professional, right? If you don't compromise with your independence, perhaps the problem is not there, right? You will not be questioned with regard to your integrity. Only difficulty arises when you work hands in gloves with the corporate debtor as a part of some conspiracy. Maybe you are aware or maybe you are not aware, right? So in those cases, you need to filter as to whether these cases are genuine one or not genuine one. I know it is very difficult on the face of it, but yes, you have to develop and do a bit of due diligence before entering into such kind of trap. Many of the professionals have got trapped in the beginning of this 2016, 2017 when this processes started. Many people thought that this is a law by which they can launder many of their ill deeds in the past, and they'll be able to get rid of the liabilities. And many of the cases, the promoters have been caught and the insolvency professionals also have been caught. But as long as you are clean, your conduct is clean, you are unbiased, you are maintaining your professional duties and ethics, should not there be a problem. But message is loud and clear. We need to be alert. We need to do a proper due diligence before accepting the assignment. I know easy said than done, especially if you are getting the matters through NCLT, where they come as a surprise to you. So you are not sure as to whether how to do the due diligence. You don't have a choice even. You cannot reject because you have already given a consent that you want to be appointed. You will be ready for taking the appointment. Now you cannot reject, right? So be little cautious while choosing the option also, whether you want to be on a panel of a particular NCLT bench or not, whether you want to be on a panel of a bank or not. So if you want to do selective cases, enjoy like me that I don't give my name as a panel for the purpose of adjudicating authority. So I have a freedom that I will do matters as per my choice and as per my due diligence. After only that, I undertake the matter. So depending on your own comfort, you can do, but there are safeguards. As long as you are playing independent, there should not be a problem. Let me take you through the most important and most critical part of the role of a related party in relation to the CIRP process. Now, first and fundamental question, I think we all have the answer. What is the position with regard to the appointment of related parties as a IRP or RP? Very clearly, if I am a related party to the corporate debtor. Now, how you become a related party? That is a long list that is provided in the related party definition. If I happen to be, that is 5 clause 24, you have to tick box that you should not qualify in any of those people. If you are, then you don't take the assignment. If you are not, then you are eligible to take the assignment. Now, second point that comes, whether there is any restriction on appointment of related party as an authorized representative. Now, you know in which cases you are required to make the authorized representative. Authorized representative means where there are more than one class of creditor. The regulation 4A talks about. So, not only related party, but if I am Amit Gupta is a IRP and my brother is also an IRP, I cannot appoint him as an authorized representative in my matter and vice versa. Of course, the related parties can also not be appointed. The related party of corporate debtor, here we are talking about. So the IRP will identify the 3 insolvency professional who are not his relative or related parties, right? So basis that you will be doing a tick box exercise, and if you don't qualify in that, you will be able to make the appointment.
Sir,
Now,
question is same is true for IPE also?
Yes, for IPE also. So let us say I am a insolvency professional and I have a IPE also, right? So I cannot appoint my own IPE as an authorized representative for the purpose of authorized representative, right? I cannot.
In registered valuer or director of my IPE, who is the registered valuer, or I cannot also appoint?
That I will come. For there are restrictions on the registered valuer appointment also and the other professionals appointment also. But as far as the IPE is concerned, to best of my understanding, if I am an insolvency professional and in which the other entity, which is the IPE, where I am also one of the director or partner, and I want this IPE to be appointed as a authorized representative, answer is no. It is a clear case of conflict, whether it is coming in black and white or not, but I don't think, because since after the IPE amendment has been done, I think a corresponding amendment in these particular provision, the provision that I was reading in the past, has not been done. But let me find out. I think they must have plugged it, or they must have made a general statement that whatever restrictions are applicable on IP will now be read to be applicable on the IP mutatis mutandi. I'm yet to find out that particular clause, but it must be there somewhere.
Can a flat buyer of the particular project become IRP or RP of that project?
Flat buyer. Flat buyer is not a related party. So
Okay.
if let us say I am Amit Gupta and you are insolvency professional in company in a corporate debtor, and I have made an application for the flat in the corporate debtor, whether I can take the assignment or not, I don't think that there is any restriction with regard to this, but related party, at least it is not covered. Or is there any other clause in which I can fall? Let me just check.
Because flat buyer is not related to CD, no?
Yeah, it is not. That is what I am also trying to understand. Means if I go in this condition, these are
at the most he can be interested party, but cannot be related party.
Yeah, he can be at the most be the interested party, because these are the only disqualification. If I see the explanation, he is eligible to be appointed as an independent director. So now, yes, this is interesting clause. Now, if 149.6, in 149.6, if we can be covered in this condition or not. But let me park now, because 149.6, there are many conditions, some 10, 12 clauses are there. We can examine it clause by clause so that I can give my final answer. But prima facie, it looks it should not be restricted. But I'm just keeping this question parked, and maybe end of the session, either we will do the examination or I will discuss it separately. But prima facie, it does not seem to be restricted. Now, another important question that keeps bothering to all of us, that I have received a claim from the related party. Let us say same example. Amit Gupta is the director. Unsecured loan of 1 crore was given. Now, while ABC Limited went into CIRP, Amit Gupta also filed his claim. As a IRP, whether you are required to admit this claim or not. Answer lies in regulation as well as form. If you see the form C and form CA, form C is for financial creditor and form CA is for the class of the financial creditor. Form B is for operational creditor. I will definitely file form C. I will be required to give a declaration that I am a related party. Similarly, if a class of creditor is filing, he will also make a declaration that I am a related party. Now, if I have supplied the goods to the company, I am a raw material supplier. Very interesting finding that form B does not ask you for making such declaration. I don't know why, but if you go through the form B, nowhere it asks for the declaration similar to what is prescribed in form C or form CA. Let us move little further. We will conclude thereafter. The duties of IRP or RP are specified in section 18. As soon as the person is appointed as a IRP under section 17, he becomes, you can say, a CEO of that organization, and the board of director is suspended. The power is suspended, right? Now, IRP is required to receive and collate all the claims submitted by the creditors to him pursuant to the public announcement. What is the role? The role of a IRP in this case is limited to receive and collate. He will simply sit here, note down that I have received a claim from a financial creditor, Mr. A, who is a related party. Law does not restrict IRP from making admission of claims submitted by either operational creditor or financial creditor who is a related party. Maybe there is a distinction between the declaration that is being made while filing a Form B or Form C. For Form B, no related party disclosure is required to be made. For Form C or CA, the related party disclosure is required to be made. Now let us see the reason also why it is so. If you move little further with regard to the space in the committee of creditor, you will get the answer. The related party can be member of committee of creditor or not has been dealt in section 21 and regulation 16. What are his voting rights? That is also dealt in section 21. 21(2) says the committee of creditor shall comprise all financial creditor of corporate debtor. However, the financial creditor or authorized representative of financial creditor referred to in subsection 6 or 6A of subsection 5 of section 24, if it is a related party of the corporate debtor, shall not have any right of representation, participation, or voting in the meeting of the committee of creditor. Now, first question, whether he is a member of committee of creditor, answer to my mind is clearly yes. He is a member of committee of creditor. That means he is entitled to all the notices of meeting of committee of creditor. He is entitled to sit there in the discussion, but he will not have a right to participate or vote in the meetings of committee of creditor. So that means he has got zero voting right. Maybe I'm having 1 crore of debt, maybe it is 10% of the total debt. If let's say total debt is 10 crore, but still I'll have no voting right. I'll have no participation right, but I'll have a right to notice. I'll right to attend the meeting. Participation means in discussion I cannot participate, but I can be available for answering the questions, as has been observed in many of the judgment by the Supreme Court, that these class of people are necessary for fruitful conduct of the committee of creditor. Similarly, if a related party is a financial sector regulator, let's say I'm an NBFC, that means there is another company XYZ of which is related to ABC Limited, which is an NBFC, and they have given a fund to ABC Limited and they had filed a claim. And by virtue of substitution of debt into equity or any other convertible instrument, they have become a related party, then they will not be restricted. That means this restriction, if prior to commencement of insolvency, they have converted their debt into equity, and by virtue of they happened to be the related party, they became the related party because of this conversion, then in that case, the restriction what we were just talking about, that restriction will not be applicable. Somebody was asking about the registered valuer. In registered valuer also the related party of the corporate debtor word is used, or a relative of liquidator. Similar provision, I think this provision is for liquidator, but similar provision exists for the insolvency professional also. A relative of insolvency professional or resolution professional is also restricted from. This provision is certainly because it talks about 5-year auditor restriction. This provision does not exist in case of. So I cannot appoint somebody as a registered valuer who is a related party to the corporate debtor. That is also one of the finding. Restriction on appointment of related party for availing the professional services. Now, I am running a CIRP. I am not a person from the technology, and the company in which I am appointed as a CIRP, as a IRP, is in telecommunication. I need to engage the telecommunication expert. You can engage anybody, but you cannot engage someone who is a related party to the corporate. Or you cannot appoint somebody who is a relative to the resolution professional. However, mind the word, it is not related party of the resolution professional. It is only a restrictive definition. That means relative, and relative here will mean, because the term relative has been defined in the act. You have to use that definition, which is limited one, not the expanded definition which is provided in the explanation in the 5 clause 24a, right? So very limited number of people will be falling in the restricted category. Otherwise, all the other people can be appointed as a professional. Then what are the restrictions in doing a related party transaction? Now, what resolution professional can undertake as a related party transaction? Let us say there is a going concern. It's an automotive industry, ABC Limited. ABC purchases the engine from XYZ, which is a related party of ABC, which happens to be the, you can say, entity owned by Mr. A, who is a director, or his son, who is a director on the company. So it is ultimately a related party. Now, if you want to, because engine may not be available in the market, if you want to keep your concern as a going concern, you may have to undertake. Similarly, there may be n number of transactions which you are required to do. You all of a sudden coming into a company cannot just shred off all the transactions. You will have to continue those transactions, of course, at an arm's length and the fair price. Now, section 28 only asks you to take the prior approval of committee of creditor wherever you are doing any such kind of related party transaction. But you can certainly undertake these kind of related party transactions. Now, another interesting part is what is the role of related party in submitting the information memorandum. Now, you know how important is the information memorandum. Information memorandum contains information about your company. What is the background? What is the financial health? What is the asset? What is all? That is the document by which the prospective resolution applicant understand whether he should go ahead with this deal or not. So regulation 36 is specifically mandate and require you to give the particulars of debt which are due from or to the corporate debtor with respect to related parties, so that the resolution applicant or prospective resolution applicant is able to decide कि भाई इनका क्या करना है, how much we have to pay, how much we have not to pay. Similarly, details of guarantee that have been given in relation to debts of the corporate debtor by other person, specifying which of the guarantors is a related party. All right. So you have to provide these information in relation to the information memorandum. Yes, sir.
With regard to this one point which was discussed about registered valuer being appointed by from the IPE, it is always better and advised that the matter is put before the COC and the approval is obtained. Even because once RP becomes a corporate debtor in himself, he's a CEO. That means his partners also become related. It is always better, it's always a better proposition to get an approval from the COC and appoint the valuer or anybody for that matter.
Let me understand. So if Amit Gupta is a IRP and I have a IPE, right? So one aspect we have discussed and parked that I cannot appoint that IP as an authorized representative. That is one which is clear. Now, another point which we are examining, that let us say I have another registered valuer entity also, right? Where you're talking about which RVO, registered valuer entity.
See, what I'm trying to convey is, for example, you have a partnership firm. There is one more partner who is actually who is advised to be a process.
Partnership form of what? Valuer.
Valuer, even if it is, what to say, IPE also, no issues on that. For example, there is a person who is very much involved in that process of that industry. For example, you're one of your partners. It's always better that you can put forward that point in front of them to the COC. It is only the commercial terms and conditions are to be at arm's length price. It should not be exorbitant. If the COC approves, it can be done. Similarly, it applies to a registered valuer also. Because for each and everything, having a person of your own choice, it's not your choice, but one thing is, it is with regard to his professional ability to perform that duty. That is the first.
I agree.
That is the first one. That is the first point to be considered, and it is up to the COC to decide to whether to have you or not to have you. Because when the value, when you appoint valuers, I will be a part of my team. That is, he's a partner in the other firm. It is always declared. It is up to the COC to decide which one to take it up and which one not to take it up. Because it is not in your hands. It is not in your hands to appoint any person. And every approval has to be obtained, even for forensic audit, even for anything. It is all commercial in nature. So that is my viewpoint.
All right.
But I would just to add that if I am an IP director and my partner is also a valuer, in my assignment, I cannot appoint him as a valuer because as per the specific section we read out, there is, if I am a partner of IP entity and that one of the partner is also a registered valuer and IP, I cannot appoint him as a registered valuer. In my case.
Yes, that is correct. Because in earlier slide, it was mentioned that partner cannot be your authorized person.
Partner cannot be appointed as a registered valuer or an authorized representative, or in whatever, even forensic auditor cannot be appointed.
Yes,
if he is related. If I am a IP entity, my director or partner or the registered valuer, they cannot be appointed.
Sir, it is nowhere said that you have to get the approval from the COC. It is not you, but you are declaring the fact that this concerned person is my relative, in the sense related to me. You are declaring that to them.
But that section is
That
still
is the
that
only
not
point.
appointed.
Fine, if that being the case, it should be that. But one thing is, I don't think so. For example, there might be some consultants who are specialized in this aspect of it. You might be better equipped to handle that matter. It is not that CRP is just a normal one. There are several cases where we find specialists are required. So if you have a specialist, it's up to the COC to decide.
No, Shivraman sir, I think the point that the person is trying to bring in, if there is a specific restriction that
If there is a restriction, then it cannot be. But normally
so-
what? But normally
So
what people do is
we have to go as per the mandate of law. If the law is clearly providing in a particular frame that this RVE cannot be appointed because of so and so restriction, then it is gone. Otherwise, in general, what Shivraman is saying is if there is no direct prohibition, but still you are appointing a related party or interested party in capacity as a registered valuer or any other capacity as a professional for the purpose of doing any of the assignment with the CIRP process, then you need to put the matter before the committee of creditor, seek their concurrence, and then go ahead. I think that is a fair point, and there is no disagreement with regard to doing this way. But if it is restricted, then certainly it cannot be done.
Sir, for example, valuer and forensic auditor are appointed. Okay. There are other auditors also, no, sir. For example, GST audit hoga. Sab kuch hota hai na, sir. It is not that, it's not only a specific. I'm just giving an example. It's not that GST auditor is
That
separately
will
done.
come in the capacity as a professional, right?
Yes.
For that, there is a regulation 27, right? That we discussed. So there are only limited restrictions. In those restrictions, you cannot appoint. Rest all the people you can appoint. So other people also, if they are interested, you are interested in that, like we do a related party transaction in the company. The related party transactions per se are not bad and they are not restricted. What is restricted is a disclosure. So here the body to whom you are making a disclosure is the committee of creditor. With their approval, you will be certainly be able to do those kind of transactions.
Yes.
Unless it is clearly restricted.
It is
Sir.
restricted.
Sir, it is very clear. Sir, my name is Sanjeev. It is very clear as per this regulation 27 that this relative of resolution professional and related party of the corporate debtor. So this two bifurcation is already given, and if IPE wants to appoint any related party of the corporate debtor, then he cannot do. And but if IPE wants to appoint any related party of this IPE itself, then
No,
they
so for appointment of a professional, this is a regulation 27.
yes.
What it restrict, provided that the following person shall not be appointed, namely a relative of resolution professional. Is he a relative? Answer is no. Is he a related to corporate debtor? Answer is no. Right?
Yes, this it is clear.
So we have to see. I'm saying what I'm saying is you have to apply the tick box check. If it is restricted in a particular regulation, you don't have a choice whether you appoint or not. You cannot appoint. But if it is not restricted and if you are interested in that particular agenda, then you need to put this agenda before the committee of creditor so that you get necessary concurrence, because ultimately the financial approval has to come from the committee of creditor. They have to approve it as a part of CIRP cost also. That's the point. Now, let us come to role of related parties in the resolution also. Now, 29A is a perhaps most talked about subject. I'm not, of course, going into the length and breadth of the other areas, but let me just give you the perspective. The perspective is that a person is considered to be ineligible for submission of resolution plan if the person who submits the resolution plan, or any other person who is jointly submitting the plan is undischarged insolvent, willful defaulter, or his account at the time of submission of resolution plan has been NPA for period of at least 1 year. Or let us see the broad condition, then we'll come. Or has been convicted of an offense which is punishable with imprisonment for 2 years or more,